আমি ছয়। তুমি ছয়।
না, ৮ থেকে আমার ৫
এই বল ছয়তে, আমি তো ছয়তে আছি জয়। কেউ লাইন করলেন তো?
বেরিয়ে যাবে।
ছয়তে আছি জয়, আমি তাই বিশ্বাস।
এই অসুবিধা।
আজকে আমাকে আগে ঘুরতে হবে, আগে তুমি জয়টা করে নে। এটা কি আজকে শুনে আছি তোমাকে?
There is for judgment item number 1.
No, no, what it? Sorry.
Petitioner. I appear for the respondent.
In view of the foregoing analysis and having considered the additional authority cited on behalf of the appellants, this court is of the considered opinion that the impugned order dated 10/6/2025 deserves to be set aside to the extent indicated. The directions in para 22 of the impugned order insofar as the direct affirmative disclosure of RA bills, particulars, disclosure of books of accounts, profit and loss statements and the balance sheet, validation and submission of revenue record, and forwarding of copies to the respondents are beyond the scope of section 17 and are accordingly set aside. If the respondent seeks production and inspection of such documents for the purpose of the arbitral proceeding, they shall be at liberty to take appropriate steps before the learned arbitrator under section 19 of the Act. The appeal is accordingly allowed and disposed of. It is clarified that any expression disposed of.
Much obliged.
Grateful.
Lord, may I have your leave to mention one matter, my lord? Extreme
Not
urgency,
now.
my lord. My lord, leave to file, my lord. We have already filed an application, my lord. My lord,
Tomorrow,
the demolition
tomorrow.
drive is going on, my lord.
Not today.
My lord, I beg to your pardon, my lord. My lord, I've been told, my lord, if the matter is not taken up, and anyway, the demolition drive will be completed by today, my
What
lord.
demolition?
My lord, demolition at a building, my lord, at Chingri Gata Lane, my lord, Tengra.
Why are you mentioning before me demolition matter?
My lord, there was an order passed by my lord, my lord.
Yes.
My lord, we are an occupant of the that building, my lord.
Yes.
We are never been heard, my lord, in this
That's
matter, my
all
lord.
right.
We have filed an application for modification of the earlier order passed by my lord, and
Nothing
also for
doing.
intervention,
All
my
these
lord.
unauthorized construction should go. Nothing doing. No urgency.
My lord,
Yes.
only
Sorry,
an
no.
opportunity of being heard may be
No, sorry,
granted, my
sir.
lord, my lord.
You have missed
Nothing
the
else,
bus.
my lord.
You have missed the bus. You should have been here on time. All right. No mentioning right now. Take out the matter. Orders are passed in contempt. I know why you are here.
My lord.
May I?
My lord, may
I know why you are here.
my lord, may I say, my lord, we have,
No,
we have
nothing
already
doing.
filed an application, my lord,
Nothing
before the
doing. Go
coordinate bench,
before the
my lord.
committee.
My
Nothing doing.
lord,
Nothing
that
doing.
application is pending assignment, my lord.
Nothing doing.
May
Yes.
I have my lord's leave to mention this matter, my lord. 7 July 2026 order is
No mentioning.
no, not mentioning, my lord.
Yes. Yes.
My lord, there's the warrant of arrest was issued against award hold debtor number 2. It should be 1B, my lord.
All right. File दिखाना है एक बार इसका. File है.
I have that order, my lord.
No, who's 1B?
1B is the second award debtor, my lord.
Who was 2?
2, there's no 2. There's no 2, it's 1B, my lord. With amendment was carried out, so we missed it.
All right.
My lord has done? Okay, great.
Item number 2.
None for the petitioner. In the interest of justice, adverse orders are deferred. List on next Tuesday. You need a holiday. 2, 3, 4, 5. Same.
Item number 3.
Same order.
Item number 4.
Same order.
5.
Same order.
Item number 3.
was to give a reply, my lord, Mr. Shah, Mr. Joy Shah, my lord, that RERA matter, if your lordship remembers.
Yes.
Oh, my lord, Mr. Shah is online.
Yes, Mr. Shah.
Do forgive me. Do forgive
You copy, my lord?
The problem is, Mr. Ray,
me. I'm so sorry.
signals are never good. Impossible to actually.
Absolutely, my lord.
It frustrates you actually. Mr. Shah, signals are not good. Yes, tell me. Where are you?
Malad, I can be, Malad, just today accommodate me, Malad. Any day, Malad, I'll be
I
there.
thought
with you.
Are you not done with your arguments?
Malad, I'm finished. I may have to rejoin, Malad, to what Mr. Ray says.
your lordship
Your
permits
Lordship has heard me, given me an extensive hearing, Malad. Today, Mr.
Or
Ray
next Tuesday.
Tuesday, my lord.
Keep it for next Tuesday. I can hardly hear him.
very
I
well.
asked, my lord,
He has to rejoin also.
Yes, yes.
I have to keep it on.
Malad, I'll come back on next Tuesday. I'm deeply obliged.
next Tuesday, my lord, I'm not.
You're not here.
My lord, that is my only problem, my lord. So then, my lord,
Then next to next.
John, don't do this.
Next to next.
Why will we do that?
Keep it after 2 weeks.
Are you out of your mind? The judge is not wanting to hear.
After 2 weeks.
And could you, my lord, the date may be
Very well,
kindly.
At the request of the learned counsel for the petitioner, let this matter be listed on. Learned senior counsel for the petitioner, let this
Let
matter
it
be.
retain its position, my lord, only, my lord.
Yes,
Because the arbitrator is not proceeding, in spite of there not being any order, my lord.
let it also retain its position so that we can finish it.
I wouldn't have said this, but the
Yes,
arbitrator
yes,
being
Malad.
my lord, old school, my lord, says that the appeal is
We'll
there. My lord.
finish it because, even if I hear you today,
I understand, my lord. I
he's going
understand.
to rejoin. I can't do it.
I understand, my lord.
This will,
My lord, doesn't look that side, my lord. It's always the solicitors, my lord, who are always in a hurry, and the client, my lord. I do understand, my lord. Definitely, my lord. He'll come back on the 11th, my lord.
is this-
11th May? Oh, God.
what?
On 11th also, I'm not there, my lord.
Tell me, up to you, your convenience, Mr. Ray.
My lord, could it be any time in this week? No, it only takes up on Tuesdays, my lord. Or any day in
Malad,
this.
so we'll come
Non-commercial.
to your Lordship on the.
Sorry, Mr. Shah.
I'm sorry, Malad, I
No, I couldn't hear you. And that's the reason
can't hear the date, Malad.
I'm not. No, I've not given a date.
Could it be on the 6th, my lord, if it's
Malad,
possible, my lord, that's a
I'm
Thursday. Any day this week, my lord, any day.
Six is also.
Thursday, I'm keeping for now 34th, because I'm not able to touch the 34th. So I'm trying to keep 34th on one, at least half a day, that we can finish off some 34th.
Then may I request, my lord, may I complete today? I wouldn't take too much of time. If it's, and they can rejoin the next day, my lord. If it's commences to your lordship, my lord. Or else it's, I understand, my lord. I'll keep it, my lord. Very good. And then that's got to be the 18th one. My lord. I understand, my lord. No, my lord, yes. I'm so sorry, my lord. I'm very sorry, my lord. Yes, my lord. And 11s, generally, everything, my lord.
Malad, 18th is already.
My lord. But it's my folly because I the 2 dates, my lord, I had some problems, my lord. That's my problem. Very grateful, my lord. Grateful.
Your Lordships, I do not wish to intervene in between the proceedings
Don't
of
do
Your
that.
Lordship. My junior mentioned a matter in the morning. Your Lordship, I'm just requesting to allow me one chance at 2 p.m.
Sorry, madam. Nothing.
Lordship, they will all come on roads, Your Lordship. They are
Let
poor
them come on
children,
the
women.
roads. Unauthorized construction, I have no sympathy.
Your Lordship, I don't mind. Let it get demolished.
I have no sympathy for unauthorized construction, and please do not mention in it.
But
number 7.
My lord, I am led by the advocate on record appearing for the petitioner, my lord. Learned advocate Mr. Avila Chatterjee is suffering from a high fever, my lord. I am praying for one accommodation.
Again,
No, he was there on the last occasion, my lord.
one day he comes, 2 days he doesn't come. What's the problem?
Suffering from high fever, my lord. Praying for one accommodation.
Learned proxy counsel so and so states that the main arguing counsel is indisposed.
Grateful lordship.
She prays for an adjournment. Let this matter be adjourned for how much time?
My lord, only this week, my lord, he is suffering from high fever.
After 2 weeks.
Grateful lordship.
My lord, in this matter, I am the petitioner. My lord, last occasion, I have served the copy supplementary affidavit to the learned advocate of the petitioner. But your lordship pleasure to serve another copy to the opposite party, respondent. That's why I have served again. This is my affidavit of service. My lord, supplementary affidavit in regard to that. My lord, I have filed the Section 11 application. My learned friend appeared in the application suppressing the material fact. He has filed a case before the consumer forum. My lord, kindly
You
come
are for
to,
the petitioner or the respondent?
I am the petitioner.
Yes.
My lord, kindly come to page 7 of my supplementary affidavit once.
Yes.
In section 11, my lord, 9th December 2021 order was passed. And my lord, then my lord, next page, page 8. Suppressing the material fact, date of filing of the consumer forum complaint, 4/8/2022. And obtained an order, ex parte order, and only this is the predicament I have come before my lord. And if the execution is filed, though I have filed an appeal,
If you have filed an appeal, then
yes, my lord,
how is it maintainable then?
in consumer forum.
Yes, but how is it
It is
maintainable?
already obtained an alternative remedy, lordship. So this,
But
Then how
my lord,
the
filed a execution case. He filed execution case, not to proceed the execution case, only on that. At the assurance of my learned friend, I have.
this
It's a
is not
different remedy.
maintainable.
And my lord,
It's not maintainable.
deeply
my lord,
obliged.
let it record, I have filed the appeal.
Learned counsel for the petitioner states that he has filed an appeal against the
Short date
order
may be
passed
given.
by the consumer court in CC number 245 of 2022. Has filed an appeal against the order of disposal in CC number 245 of 2020. Order against the order of disposal of the CC number 245 of 2022 dated 22/4/2025.
কিন্তু সেই ডাকটা তো ওরা
In view of the same, he wishes to withdraw the present petition with liberty to proceed in accordance with law. The present petition is dismissed as withdrawn with liberty as prayed for.
My lord, short date may be fixed for hearing.
For what?
My section 11 application?
How can you
That
proceed with the section
dismissed.
11 if you have already taken the remedy?
No, my lord, section 11 earlier filed.
Earlier filed, but you have.
My lord, what happened, my lord? What happened, my
Let
lord?
them file. No, let them file the reply to this.
Yes, my lord.
Have you filed your reply?
No, not yet, lordship.
File your reply, we'll dismiss it. But why should even I allow that?
Lordship,
We'll dismiss it.
that
like
is the
this.
main thing. He have already
I'll
obtained the
do
alternative
matter.
remedy.
My lord,
Section 11 does not
subsequently say,
apply at all.
I'll dismiss it like that. Yes,
subsequently filed this application before the consumer forum.
that's all
My
right.
lord,
sir.
suppressing the material fact.
Why didn't you file? You have availed the forum of the consumer court by filing an appeal.
Appeal because of that, my lord, he have filed the.
Sir, you should have filed your application
Before
before the
this court.
consumer court or before here. You have done nothing. You're
Lordship.
coming after a long time. Why
No,
should
my
you
lord.
detain this?
My lord, he has also filed after a long time against that.
This is
My
not
lord,
made
what happened?
today,
My
sir.
lord, may I submit? My
Yes.
lord? What happened? My lord, agreement was made between the parties. There was the agreement, arbitration clause. My lord, there is a clause that if he claim the refund after deduction of 40%, he will get. I have made payment of 40%.
I'm not concerned with the merit of
And
the matter.
rest.
মেরিটে আলোচনা করে সময় নষ্ট করে কি লাভ করবে?
Then, my lord, section 11 application may be continue. I will withdraw my appeal.
You make the statement and your appeal is withdrawn.
Yes, I will withdraw my appeal.
Is this the way to withdraw an appeal?
No, I will.
Kind of a what is
Lordship,
it?
is it permissible under the law? What he is
But
paying for?
this is the
You make a
subsequent
statement and
application.
the case is withdrawn.
This is the subsequent application, my lord.
Whatever you ought to have come before this court earlier.
আমাকে বলতে
না, না,
দাও।
নিশ্চয়ই বলুন।
This is the subsequent application for suppression of material fact. My lord, this is the several two remedy, my lord. One is the section 11 application for appointment of arbitrator.
Why didn't you move a section 8 application?
Section 8 application I have not filed.
Then
My lord,
how is it maintainable today?
actually consumer forum did not accept the section 8 application. Several judgment is there that is the separate forum.
Did you file it?
No, my lord. I have not. Expertise order was obtained. How?
The-
The right of service not appeal.
Expertise order.
You argue, I'll dispose it off. Argue, I'll dispose it off.
My lord, petitioner entered into an agreement for purchase a plot of land. My lord, page 16 is the agreement. My lord, petitioner entered into agreement for purchase of a plot. Thereafter, he refused that he asked that the plot in question are acquired by the New Town project. I have satisfied. My lord, page 22. It is not acquired. Subsequently, petitioner choose another land. I have entered into agreement, that is page 24, for purchase of a land according to choice of the petitioner. And made an advance for purchase of a land. And my lord, that is the earlier occasional page 30, that record of right, that the entered into agreement with the Kunjo Sarkar, and that is the land of Kunjo Sarkar. Thereafter, my lord, petitioner make an application for refund of money. My lord, now, my lord, kindly come to page 18.
Page?
Page 18 of my agreement. A running page 18.
Yes.
Second party shall make an application for refund. He made an application. Deposited amount, first party shall refund the amount after deducting 40% service charge, second party within 30 days. That's 40%, after deducting 40%, I have paid the entire amount. Why I have deducting 40%? Because, my lord, the respondent come through an agent, marketing agent, and I have paid the commission, that is page 31 to all this page commission to the marketing agent. That's why 40% was deducted, and then that was payment. And my lord, thereafter, the arbitration clause, my lord, in the agreement, that is at page 20, paragraph 18. All dispute and difference whatsoever, dispute regarding the balance amount, I have paid the 40%, deducting 40% all amount paid. Dispute regarding 40%. All dispute difference whatsoever arising between the parties thereto or person claiming under the terms and condition agreement shall be mutually settled, and the case, the difference shall not be settled mutually, then the dispute will be referred to arbitration. That is the arbitration clause. Then, my lord, the supplementary affidavit, first time, it on 9th December after notice, the opposite party respondent appeared, and my lord,
Did you file your first section 11?
section 11 application.
Yes.
Coming. Affidavit portion. After before December 21.
So what happened in your first section 11 petition?
My lord, that is the order of my annex, page 7
Yes.
of my supplementary
You
affidavit.
left it after that.
First order. Well, he appeared.
So you abandoned the application. Where's the application? AP 406 2021. What happened to it?
This is pending.
And then you again file this.
No, my lord. This application, this is the application 406.
This is 406.
Yes.
Oh, this is a 21 section 11.
Yes.
2020 section
Yes.
11.
Yes, my lord.
2021 is section 11, Lordship. Yes, suddenly
made a
wake up
clear-
in the year 2026.
Because of my lord, he's suppressing the material fact and obtained an order. That's why I have supplementary affidavit made.
All right. So this was filed in 2020.
21.
Then what happened?
Thereafter, my lord, affidavit direction was made.
Yes. Then
My
what happened?
learned friend made a pair for filing objection. Thereafter, benches change, determination change, and matter did not appear. Thereafter, several occasions mentioned, and last occasion, it
Where
was
are the
mentioned before your lordship.
Where are the order sheets? Where are the order sheets? Where are the order sheets?
Yes, my lord. All order was not with me today, my lord. Several occasion matter was appeared.
Who went to the consumer court? Who went to the consumer court?
Lordship, I am the agreed person because I have paid the 45 lakhs. After his submission, I may start. Issue is that, Lordship, there is a requisite.
Let him. Yes.
My lord, only question is, my lord, 21, I have filed this application.
Yes.
And my lord, thereafter, my lord, it was appeared in the year May 22. My lord, order is not with me today. Thereafter, 28/7, it is my endorsement. I can produce in next day. Thereafter, my lord, my learned friend party made a prayer for filing objection. He has not filed objection. In the meantime, suppressing all this material fact that pending the arbitration application section 11 is pending before the honorable court. Nothing, no whisper in the said application. He filed the application and obtained an order, and that was put for execution. My lord, 21, it is application for 2021 arbitration application, section 11 application, and he filed the application before the consumer from 4th August 2022, after 8 months.
Why did you participate in the consumer court?
Yes, my lord.
Why did you participate? Why did you go to the consumer court?
My lord,
Why did you contest it? The judicial authority.
I have not contested.
You have contested it, sir.
The ex parte order was passed.
No, you have contested it.
No, my lord.
Action is brought in matter. Yes.
My lord, let this section 11 application me.
Yes.
If the section 11 application continues, I need to file on WO because already the the agreement my learned senior friend is referring to already has been cancelled by the director of the Leisure Country Club, who has affirmed the supplementary affidavit, who cancelled the agreement by an email in the year 2017. And that particular email, he has classified that in 7 installments, he will pay the entire amount, not deducting anything. Lordship, grant me any single chance, I shall satisfy your lordship.
I'm giving you a chance right
Lordship,
now.
I don't have the documents today. I need to file a
We
double.
are not getting into the merit of the matter, sir. You just tell me how this petition is not maintainable or maintainable.
Lordship, not maintainable because he ought to have come before this court before 5 years. He has already served
There is no time limit before 5 years or 10 years.
he has already received the copy of the consumer court. Despite of that, he has not appeared before that court to ventilate his grievance that there is arbitration proceeding pending. After the execution proceeding filed, he has moved an appeal. During these 5 years, he has not informed this court also. Suppressing this material fact, I have already filed an application before the consumer court.
He has not filed an application before the consumer.
Lordship, nothing.
You moved the consumer court.
Lordship, because I am the aggrieved party. I have paid the 45 lakhs to him.
There's an arbitration petition which was still
Lordship,
pending. How did you file a consumer court
That
when
is
the
the
arbitration
thing,
petition
because
is
arbitration petition itself not maintainable because the party has already cancelled it. The Leisure Country Club, Lordship,
cancellation of agreement means the petition is not maintainable.
if the arbitration clause is there in the agreement, if the agreement does not exist, arbitration clause will prevail.
Yes, it will prevail. Yes, it will prevail.
If it will prevail, then the section will, then I have to contest in merit.
Yes, you have to contest on merit.
Lordship, kindly grant me a chance to file my W.
Why should I? I'll refer it to arbitration.
And agreement has been cancelled by declaring.
What? If the agreement is cancelled, whether it has been validly cancelled, not cancelled, all
Lordship,
that aspect will be looked into by the arbitrator.
Lordship, what my learned senior friend is disputing.
Why didn't you file your affidavit in opposition since 21?
Lordship, that is
Why should I grant you any time?
Lordship, tendering apology for
No
that.
tendering apology, sir.
7 days ago.
For 6 years, you have not filed your written opposition.
Lordship, grant me 7 days.
I will give you no time.
Lordship may pass your lord.
You have been sleeping over it. You know that there is a proceeding which is pending. Still,
I have
you
not
went to the
filed the
consumer court.
application, Lordship, section 11. He has filed this and already application, or he has cancelled the agreement.
You
So that I have moved before the
you
consumer
withdraw
court.
your appeal to that and come here.
Yes, my lord. I will.
I'll keep it for next week. You come back next week. We'll appoint an arbitrator. He'll look
Lordship, in
into
the
it.
meantime, any WO may be granted.
Why should I grant you after 6 years? 6 years you have not filed it.
In the meanwhile, Lordship,
Why in the meanwhile? What were you doing for last 6 years?
Lordship, not my application.
This is a direction from the court.
Lordship, I have
You have taken time to file your affidavit in opposition.
Lordship, I shall file within 7 days. Lordship.
9th November 2021.
Lordship, I have seen it. To tendering apology. Fine.
Down. The petitioner had preferred the present section 11 application in the year 2021. There was a direction given by this court by order dated 9th December 2021 to the respondent to file their affidavit in opposition. Full stop. Instead of filing an affidavit in opposition, the respondent chose to file a CC, a complaint case before the District Consumer Dispute Redressal Commission as CC number 245 of 2022. Full stop. Though knowing very well that proceedings under section 11 of the Arbitration and Conciliation Act were pending before this court, the respondent chose to file a consumer dispute on the basis of the same agreement on which proceedings are pending before this court. Same agreement dated 23/7/2014. Pending before this court. The consumer court, it's an ex parte order, right?
Yes, ma'am.
By an ex parte order dated 22/4/2025, disposed of the said consumer complaint case, directing the petitioner herein to refund an amount of rupees 18,41,000.
Due amount.
Sorry?
Due amount.
Due amount. An amount of rupees so and so, as claimed by the complainant. And further, what is this 50 lakhs? And further granted 50,000 to the complainant as compensation for harassment, mental agony, complainant जहाँ लिखा हुआ ब्रैकेट में डाल कर देना respondent here ब्रैकेट क्लोज. And also awarded cost of rupees 5,000 in favor of the respondent herein bracket complainant. Full stop. Learned counsel for the petitioner states that he had filed an appeal before the. You filed a consumer state commission.
State commission.
Where is that? Where is the order?
No, it was not admitted as on today.
Just pending there.
Yes, my.
No copy has received, Lordship.
Until I always admitted, how can?
If it's not admitted, you just withdraw it.
Yes, that's why I am saying I will withdraw it.
Full stop. Learned counsel for the petitioner states that the respondent, to avoid appointment of an arbitrator under section 11, had taken recourse to the district consumer court by filing a frivolous consumer complaint, though knowing very well that the same is barred since they had already sought time to file their affidavit in opposition under in AP 406 of 2021. Full stop. Till date, the respondent has not filed any affidavit in opposition. Full stop. The conduct of the respondent does not inspire confidence in this court, since he has taken recourse to a proceeding which is contrary to the agreement executed between the parties. Full stop. The respondent is granted one last opportunity to file his affidavit in opposition within a period of 1 week. Reply to the same, if any, within 1 week thereafter. List after 2 weeks.
Deeply obliged.
It's maintainable, sir. Your section 11 is maintainable. I'll refer it to arbitration. And this order which you have got, it's absolutely illegal.
Yeah.
Date one change karo. Advance date also. It will be like this. नहीं होगा. Extend the date. Change करोगे. फिर एक लाइन लिख लो सर. If you want to change the date, then since change करोगे तो फिर एक पैराग्राफ डाल. Chapter to the order dated 1 week. 1 week. The earlier date of 6th August 2026 is cancelled. Hence, the warrant of arrest, execution of the warrant of arrest will take time. Let this matter be listed on, then we will.
This matter.
Your Lordship, I am the petitioner.
This matter is Siddhartha Lahiri is appearing. We have the respondent number 1. I'm praying for it not today, madam.
Your Lordship,
This matter.
Your Lordship, they have been directed to file affidavits in the month of February. Your Lordship, these are purely dilatory tactics. If Your Lordship kindly sees, there are gross negligence done by the gross negligence at the behest of the respondents, Your Lordship.
Where's the affidavit in opposition?
Till date, Your Lordship, they have not filed the affidavit. It was the direction was in the month of February. That's what
Yes.
But I have been instructed that he's engaged in the matter just for days accommodation.
Where's the affidavit in opposition? I can understand. I can give you time, but where's the affidavit in opposition? Why you're not filing it since February?
Just the days time may be given, then we will file.
Your Lordship, these are dilatory taxes. There are gross negligence done by the respondents, Your Lordship. The life and limb of the residents residing in the said society is at
What
risk.
life and limb?
Your Lordship, they are illegally constructing.
The arbitrable dispute or not, that
Yes,
has to
those are disputes, and that has to be
Wait a
decided by an arbitrator, Your Lordship.
Counsel so and so appears and states that the main arguing counsel is indisposed. This court, by order dated 3rd February 2026, had directed the respondent to file their affidavit in opposition. Till date, no affidavit on opposition has been filed. One last opportunity is granted to the respondent to file their affidavit in opposition within 2 weeks from date. Reply thereto, if any, within 1 week thereafter. List after 4 weeks.
file on the next matter.
Wait, please, Your Lordship. My Lord, this is my application under section 11. My Lord, we were granted the liberty, my Lord, was given to us, my Lord, to file the affidavit in reply. My Lord, we are filing the affidavit in reply today, Your Lordship, and copy is, my Lord, being handed over to the respondent.
Yes.
I'm ready, my lord. It starts.
If
I have a
my Lord,
maintainability
kindly keeps it next week, Your Lordship, because
But I have a maintainability point in this matter. I may start then.
I'll be relying on few judgments. Lordship, kindly keeps it next week.
Where are the judgment?
Only on section 11 and a contract act, Your Lordship.
Completely dead word claim, my lord. No judgment will suffice, my lord. The Supreme Court has already laid down that dead word claim cannot be revived, my lord, by arbitration.
I'll take down affidavit and reply filed by the petitioner is taken on record. Petitioner prays for an adjournment on personal grounds. Let this matter be listed after 2 weeks.
1 week, my Lord. Next week I'll be.
Okay. After 2.
If he gives the list of the judgments earlier, then I can deal with
Give a
it.
copy.
Great.
This is my application, my lord. But my lord, from the list, my lord, it seems that a GA has been filed. But I came to know from the website that that has been filed by the respondents. It has not been served till date upon me.
Where are the
Section 11 is ready for hearing, my lord.
They're not here. Next week.
Yeah. May I file my lord affidavit in reply, supplementary affidavit?
Next week.
Very well.
Item number 12, Lordship, I am for the petitioner, Lordship. In earlier occasion, there was a direction, Lordship, to amend the cost title within 2 weeks, Lordship.
Yes.
But it has not done, Lordship. Kindly extend the time, Lordship.
Are you not doing it? They should be dismissed on this ground only. Last time also I've given you time.
Lordship, there was a direction to extend the cost title, Lordship. But Lordship,
Have you seen the last order?
yes, Lordship.
What is the last order? Read the last order. Where's the file?
I don't have file, Lordship. It is my senior, Lordship. He is all out of station, Lordship.
You know what? This kind of approach is not right. We have been taking time to just change the cost title.
Lordship, department did not allow us because time has already expired, Lordship. There was a direction within 2 weeks. We have to amend the
Then why
cost.
didn't you do it?
Lordship,
What application have you moved? Argue the matter. What is the matter? These kind of matters should be dismissed. Shouldn't even encourage you. Yes, argue the matter. Tell me. Bring the file. Should not give you date like this.
then not today, Lordship, kindly.
Why not today? At least come to the court with the file. How can you appear without the file? Have you come for picnic? How can you appear in a court without a file?
My apology, Lordship, kindly.
Not today. Never appear in the court without a file. Not today.
For 13, Lordship, I am for the respondent, Lordship.
Not today. You're for the petitioner.
Yes, my lord.
You also want a date. Right?
That my application under section 11, Malad. Malad, the service has been made complete, Malad. They have refused. The service in respect of respondent number 2, Malad, was already complete. The respondent number 1 was not complete. Malad was pleased to direct Malad further service that has been done and now it has been refused. Now, Malad, the disputes arise, Malad, of a development agreement. I'm sorry, Malad, an agreement for sale which had been executed in favor of the petitioner on 6 July 2020, Malad.
Page.
I beg your pardon, Malad.
Page.
Yes, Malad. The agreement, Malad, appears at page 75 of my application.
Page 75.
Page 75, Malad.
Agreement for sale.
Agreement for sale, Malad. It was for 24 lakhs, Malad. 23 odd lakhs already paid. $23 lakh 4,000 already paid. Malad. The construction has not been commenced as of now. But my section 21 notice, Malad, will appear at page 109 of my application, Malad. Malad, the arbitration clause is there at page 83.
21 served.
21 served, my lord. That's the notice is at page 109, my lord.
Yes.
The respondent number 2 has refused and it has been served upon the respondent number 1, my lord, who's the developer. Respondent number 2 is the landowner.
What do you want? The refund of the money?
My lord, either of the two, because in the event they are not in a position, it will be, of course, my alternative prayer, my lord. In the event they cannot construct, then the refund of money.
All right, take it. The petitioner has preferred to submit application under section 11 of the Arbitration Conciliation Act, seeking appointment of an arbitrator for adjudication of the dispute and differences which have arisen between the parties in connection with and arising out of the registered. So registered agreement to sell. Agreement to sell dated
6 July.
6 July 2020. Full stop. Learned counsel for the petitioner submits that the petitioner entered into the agreement for sale with the respondent for purchase of a flat being B2 on the second floor
With respect to schedule of play.
of holding number 9/2 Haricharan Banerjee Road, Gurmat, Howrah,
74
for a total sales consideration of 24 lakhs. Petitioner submits that out of the total sale consideration, a sum of rupees 23 lakhs 4,000 has already been paid to the respondent. Respondents.
Yes, ma'am.
Under clause 3 of the agreement to sale, the respondents were obliged to complete the construction and hand over the possession of the flat within 3 years from the commencement of the construction or at the time of execution and registration of the conveyance deed, whichever was earlier. Learned counsel for the petitioner submits that despite repeated assurances extended by respondent number 1 from time to time, including representation made in October 2022 and December 2022, neither was the sanctioned building plan furnished to the petitioner nor any construction activity commenced. Full stop. Petitioner contends that even as late as December 2023, no progress whatsoever has been made in relation to the project. Full stop. Learned counsel for the petitioner states that he issued a notice under section 21 of the Arbitration and Conciliation Act invoking the arbitration agreement as contained in clause 10 of the agreement for sale dated 6/7/2020, calling upon the respondents to concur in the appointment of a sole arbitrator. Full stop. Despite receipt of the said notice, the respondent failed and neglected to take any steps for constitution of the arbitral tribunal or to respond to the invocation of the notice within the statutory period. The existence of the arbitration clause in the said agreement is not in dispute. The contention of the petitioner that the dispute has arisen in terms have arisen directly out of the agreement for sale, and are prima facie covered by the arbitration clause as contained therein. It is evident that the respondent had failed to act in terms of the agreed procedure for appointment of an arbitrator. Under these circumstances, this court is prima facie satisfied that the agreement for sale was entered between the parties and containing a valid arbitration clause, and thus the conditions contemplated under section 11(6) of the Arbitration and Conciliation Act stand satisfied. In view of the aforesaid, this court finds sufficient grounds to allow the petition, and accordingly, full stop. Accordingly, who should be appointed?
My lord, somebody who's not very senior, my lord. Otherwise, I leave it to your lordship, my lord. Not very senior because the claim is very small, my lord.
Appoint so and so as the sole arbitrator to adjudicate the disputes which have arisen between the parties out of and in connection with the agreement to sale dated 6/7/2020. The learned arbitrator shall enter the reference upon furnishing disclosure in terms of section 12 of the Arbitration and Conciliation Act 1996, full stop. All contentions of the parties on merits are kept open to be decided by the learned arbitrator in accordance with law, full stop. The learned arbitrator shall fix his remuneration in terms of the fourth schedule of the Act or as agreed between the parties. The present petition is accordingly allowed.
Grateful, my lord.
Affidavit of service taken on the court. Despite service, none appears for the respondents.
The next matter is also identical in nature, my lord. Same identical matter, my lord. Over here, my lord, it's the daughter who's the purchaser, who's the petitioner, as compared to.
Facts will be there in your 21. Where's
Yes, my lord. It's the same, my lord. It's at page 107 of my application, section 21 notice. Same date, my lord, of 10th March 2026. The only distinction is that, my lord, the property is different, which your lordship will find at page 84, my lord, schedule B.
Agreement for sale date will be different.
Identical, my lord, 6th of
Identical.
July, 6th of July.
Only the flat number is B1 situated in second floor.
Yes, my lord.
Same.
The next one was, the earlier one was B2, this is B1.
B1. And the area was 800 in
Yes,
the earlier
and
one,
that
900.
over
I've
here,
not
my
noted the area.
Yes.
Flat number change kar do. Usko page number 107.
Not very clear.
Same address here. 92 Haricharan Banerjee. Anything else?
No, no, my lord.
21 notice, same date.
Same date, my lord.
Nothing else.
Nothing else.
Consideration.
Just the schedule is different.
Consideration.
Yes, my lord. That is 27 lakh was the consideration, 26 lakh 80,000 paid.
Yeah, 27 lakhs. Page 108. Huh? And you have paid 26 lakhs 80,000.
80,000.
वहाँ पे they had paid 24 lakh, 23 lakh something, 4,000. यहाँ पे 26 lakhs 80,000.
Grateful, man. And while the same arbitrator may also be appointed because grateful, man. Deeply obliged. Grateful.
The 16.
16, I am for the petitioner. All earlier occasion, your lordship has been granted time.
Yes,
Lord, I'm,
amicable settlement.
yes, Lord,
What
I'm
happened?
paying another 2 weeks time, Lord, since the
Learned counsel for the petitioner states that settlement talks are underway. He prays for an adjournment. Let this matter be listed after 4 weeks.
Fine.
My lord, in this matter, I am appearing on behalf of the respondent, but we have not received any copy yet of this application. Kindly
Please here.
2 weeks time and leave vocal filing for vocalatnama.
None for the petitioner. In the interest of justice, adverse orders are deferred. It is noted that even on earlier date, dated 7 July 2026, none had appeared for the petitioner. Full stop. In the interest of justice, adverse orders are deferred. List after next week. Next week. You'll see if he doesn't come, we'll dismiss it.
Number 18. Number 18. 105 of 2026.
पहला वाला order है, none appears for the petitioner. Even on earlier occasion, same date भी है, none had appeared for.
My lord, I'm for the petitioner, my lord. I'm led by Mr. Subhashish Sengupta. He is appearing through my lord VC, my lord.
Lordship, will recall here in this matter, I taken
Commercial
the point of
division.
commercial and non-commercial. Lordship, before I go to the judgments, may I show the development agreement once, only specific clauses to show the nature of the agreement?
No, it looks like it has to be on the commercial side.
Lordship, because I'll just show few.
Where's the counsel?
My lord, Mr. Subhashish Sengupta is.
Lordship,
Yes, have you seen?
yes, Your Lordship, I have seen the judgments, Your Lordship. But
Yes.
if Your Lordship kindly allows me only to show the petition once.
Yes.
Lordship, this particular development agreement was executed only for the purpose of constructing a flats, Your Lordship, for residential purpose. Lordship, kindly take page 94 once.
Yes.
Lordship, page 94, Your Lordship kindly sees the fifth, Your Lordship, the column, building category residential.
Yes.
Name, mobile, email, address of the correspondence, building category residential. And
Yes.
on that basis, Your Lordship, we have already, Your Lordship, applied for the building sanction plan, and Your Lordship, we have got that particular building sanction plan. So unless and until, Your Lordship, the building nature of the building is exclusively, Your Lordship, for commercial purpose, with deepest respect, Your Lordship, it may not come under the commercial, Your Lordship, dispute. Because, Your Lordship, the main, Your Lordship, the parent judgment.
I don't.
I'll show Your Lordship
show me.
one Delhi High Court judgment referring Your Lordship division bench, because the development agreement is termed there as a collaboration agreement. So, Lordship, I can show those judgments.
Anyway, where are you? Why you're
Lordship,
not here?
I'm in commercial court, Your Lordship. That's why I could not reach. If Your Lordship kindly allow me online, otherwise, Your Lordship, tomorrow or day after tomorrow, I can come, Your
Next
Lordship,
week.
and show all the judgments, Your Lordship.
I'm sorry, my lord. Item 18, your lordship, I was, my lord, unable to connect at that time. My lord, I was for the petitioner, my lord.
Not my
I'm very
problem.
sorry.
You should be lucky I didn't dismiss it.
My lord, I'm sorry. Actually, my lord, that my parties are in the process of settlement between them. My lord, so
Whatever
on
it
that,
is, you are lucky I have not dismissed it. Next
my
week.
lord, I'm highly grateful.
Next week.
I'm highly grateful. Highly grateful.
Now also you are Mr. India. I can't see you.
My lord. Due to technical, I'm grateful.
My lord, I appear for the respondents.
Who's for the petitioner?
Mr. Nikunj Bhatia.
Is it a holiday?
I could not follow.
Is it a holiday?
It's not a holiday.
Hardly we see people. You're there.
Your Lordship, item 20. Your Lordship, this is my section 11.
Is it a commercial dispute or?
Non-commercial, Your Lordship. If Your Lordship recalls, it was listed in the commercial side as well. I took Your Lordship's leave and filed it in the non-commercial. Your Lordship, one small indulgence that I'll request for, that there is a possibility of mediation as well. The parties were in good contact with communication with each other. But if the respondents are ready,
I don't have any such instructions, my lord, that we are not in touch with the others.
Take instruction if he's saying so.
We'll take instructions.
Next week?
Next week, my lord.
oblige, Your Lordship.
New motion 1921.
Same order वो जो 16 में किया था ना, none for the petition. Earlier also same order, same date be 7th. Next week, same date, same.
Now 22.
Same order करो. क्या ना इसमें? Last पे आया है? Yeah. None for the petition. None appears for the petition. In the interest of justice, adverse order granted. Next week.
Twenty-three.
Your Lordship, I am appearing on behalf of the respondent. The counsel is not present. I am praying for a note today. Kindly keep the matter tomorrow, Your Lordship.
None for the petitioner. In the interest of justice, adverse orders are deferred. Next week.
Not today, Your Lordship.
Respondent.
Yes. No, petitioner.
And the first one?
The petitioner. Apologies, my Lordship.
How can I record none for the petitioner?
Apologies on my part, Your Lordship.
You should correct me.
Apologies.
Petitioner prays for an adjournment on the ground that the proxy counsel so appears and states that the main arguing counsel is in personal difficulty. She prays for an adjournment. Let this matter be adjourned to next week. Same order 23, 24. That's what I was thinking.
Apologies on my
25
part, Your
also.
Lordship.
Which on section 30C, item 26.
Lordship, in this matter, I am for the respondent, my lord.
For the petitioner.
Lordship, we have served the petitioner, my lordship. We have mentioned this matter. My lordship, item number 26 and 34.
You are there.
My lordship, item number 34.
26 and 34.
34. Same similar matters. My lord, same thing is there. Same.
Not today.
My lordship, it can be the hearing matters, my lordship, because the affidavit.
Not today. I'm not doing anything. Let it come next week. Nobody's here.
Yeah, and I am for the award holder in this matter, my lords. There's a short point involved in this matter, my lord. This is an application which I filed, my lord, for withdrawal of the money which has been deposited.
Position is too big. It's fine.
Lordship, initially I had served them opposition, but there were certain typographical errors. So I withdrew it by email. This is the copy. So I filed a fresh affidavit. And
It's our opposition. Let me apprise your lordship, my lords. We have filed the reply on the basis of the old opposition which was served upon us. After the reply was ready, the dates are very important, my lord. They have given us a notice that they want to withdraw the opposition just before the matter was about to be taken up 2 weeks before. They again tell us that they want to withdraw the affidavit in opposition and they want to file afresh after our defense is disclosed in the affidavit in reply. A very short point is involved, my lord. This is nothing. They have deposited the money. We seek to withdraw by giving a bank guarantee. 100% bank guarantee. Well, it's without the leave of the court, how can they again form a new opposition? Once they have served in opposition, a reply has already been.
this
You have filed it.
Your Lordship, I did not file it. I had served it. It's with me. Both the original affidavits are with me only. This is the fresh affidavit which we have affirmed because there were errors, the numbers, the calculations that were given that are not there.
Have you filed your reply to the same?
No, not this, because we have not been served. The new affidavit in opposition has not been served. It is now being served.
Your Lordship, I have served them.
Because we object to
Serve them because
the
until the
conduct of
court
the.
grants me, I had served them a affidavit, and until the court grants me leave that I can file my opposition, I did not serve them for that purpose, Your Lordship. That before Your Lordship decides it, if I serve them, that would be overreaching, Your Lordship. That is the reason I kept it to myself. I have served him today.
File your reply. Learned counsel for the affidavit in reply
Well, in that case, may I take back the previous reply? Let's.
is taken on record. Learned counsel for the petitioner is praised and is granted 1 week time to file his reply to the affidavit in opposition. List after 2 weeks.
Plus,
keep it after 2 weeks.
deeply business.
What is your opposition?
Well, it's
The opposition is mainly that they themselves have stated that they are undergoing severe financial losses.
because we are ready and willing to give the bank guarantee. 100% bank guarantee is equilateral to the amount. Well, we'll withdraw.
Just saying,
And your lordship has
will
already,
be arguing the matter. Your Lordship, in the next day, Your Lordship. Yeah.
as your lordship is, deeply honest. 27, 28. Well, 27, 28, and 29 are analogous matters. Well, let them appear together.
Similar application, no.
Section 34.
34 and 36.
27 is this application.
Yes, Mullets.
For withdrawal. 28 is
34 Mullets and 29 is 36-2. They are 36-2.
Alright.
These matters appear together, Mullets, if they can be kept together, Mullets.
and 30 is
30 is not ours.
no, sorry, 29 is
29 is their execution application. Your Lordship.
Execution act.
let these matters be listed together.
Grateful, Your
Great.
28, 29 में not today कर दो बस. That should be listed. But why don't we hear Ms. Pandey? Award is of which year?
2021.
Your Lordship, 12th May 2021, we had gone in a writ petition that was remanded back. They went from that order, they went to SLP, that was affirmed. There was an application filed by them that we wanted to deposit the money. So there has a checkered history. Your
No,
Lordship. Their delay.
They were never willing to deposit the money. That is something which I object to. Let it come for hearing, Lord. We'll appraise it. Deeply.
27, 28, 20. Only adjourned, no order. At the request of the parties, let this matter be adjourned. At the request of the parties, let this matter be adjourned to same date, de do, 28 and 29. Let these matters be listed together, better.
Now 30.
30-minute I appear for the respondent.
My Lord, Aparna Banerjee appearing for the petitioner Union of India. I am praying not today, my Lord.
Why she never comes?
Due to personal difficulties, she has not
Personal
come.
difficulty, she never comes.
May I just, my Lord, just to assist the court, one more thing I should.
What will you do with the?
No, my Lord, this matter, that is why I was indicating, because next day, another day, it will be wasted. My Lord, this is to appear on the commercial division. It is appearing on the non-commercial division.
This junior, what can you do? Not today. Tell her to come. I hardly see her.
What?
My Lord, Aparna Banerjee appearing for the respondent.
Lord,
Union.
I'm happy for the petitioner, Lord.
I'm praying not
This
today,
is
my
section 34 application. Lord, can I accept next Tuesday, Lord, we'll do it in the open court. I think personally present there.
I can't follow you, sir. Yes, tell me.
Lord, would you, Lordship, can I take it next Tuesday? Because I'll not be here.
Not today, not today.
Not.
Milord, I appear for the respondent, Milord, in 32.
32, my lord, I am for the petitioner, my lord. I have challenged this award, my lord.
Yes, Milord, I filed my opposition.
It's a old matter of 2011, my lord. There are certain grounds, my lord, that with regard to 34, my lord, that the award was not passed under the absolute terms of the contract, my lord, and there was a fraud by the respondent, my lord.
So you want to argue it, then finish it.
My lord, I have prepared one note, my lord. May I give, my lord, 2-3 points are there, and that I have to show your lordship 2-3 judgments, my lord. It's a old matter, my lord. I also want to, my lord, finish, my lord. My lord, kindly see the paragraph 2, my lord. Contractor fraudulently manipulated records by using unfair means. Here, my lord, as per clause 1138. After detailed investigation by the vigilance, it was established that the contractor has claimed and taken excess payment of 86 lakhs. But not payment taken but not legitimate, as the firm has not submitted documents as per the clause 1.2 clause 5 of the special condition of contract. My lord, this kindly come to paragraph 7 and 10 of the 7 and 10 of the petition, my lord. Paragraph 7, my lord.
It's item 32, right?
Yes, Milord, item
32, my lord. 32. 669. 669.
Are you ready for the argument, Mr. Gupta?
Milord, he can complete, Milord. I can give reply on the next
Point
day.
of having piecemeal arguments. Why you are not here?
Milord, sorry, Milord, he can conclude today, Milord. I can complete on the next Tuesday. Subject to my lord's convenience.
It's not convenient at all. Finish it next week. Give it next. Not today.
Wait a minute.
No, 33. Next one is on next Tuesday, my lord.
Next Tuesday.
I appear on behalf of the petitioner. My lord, we have challenged the award, my lord. The award was passed, my lord, in 2000. And there is connected GA that we have filed recently, my lord, few days back, because the dispute, my lord, is relating to a partnership firm, my lord. There are 5 partners. Now, my lord, 5 brothers were the partners, each having 1/5 share. One of the brothers, my lord, after issuing the section 21 notice and after section 11 application, my lord, when the matter was referred to the learned arbitrator, my lord, filed a statement of claims seeking, my lord, dissolution of the partnership firm. The other 4 brothers, my lord, they were made, my lord, parties, all respondents. My clients, my lord, they are the 2 other brothers. Out of 5, 1 is the claimant, 2 are represented by me, my lord, my clients, and other 2, my lord, they also filed an objection before the learned arbitrator. We, my lord, my clients supported the cause of the claimant. We said we are supporting the dissolution. Other 2 probably are being represented by my learned friend, says
My
no.
lord, I am for respond numbers 1 and 2. I do not want to interject, my learned senior, my lord. But before your lordship treads on the merits of the matter, my lord, there are 2 objections, my lord. One is, my lord, perhaps this has to be in the commercial division, subject to your lordship and Mr. Dev, my lord, consenting to this, because, my lord, it's a partnership dispute under section 12 of the Commercial Codes Act, my lord. It has all the ingredients of being a commercial dispute. My lord, if this be transferred, my lord, thereafter, because affidavits are completed, The GA1, my lord, of 2026, my lord, Mr. Dev would address your lordship.
That is, my lord, a new application relating to whether this is appear as a commercial division
Yes.
matter or non-commercial division matter. All throughout it appeared as a non-commercial matter. But if learned friend takes this point, I would not stand in the way. Finally, my lord, this point will be taken whether the court has jurisdiction or not, even if I succeed. So lordship can transfer it to the commercial division matter, can hear out any day. But there is some urgency because since 2020 is pending and they are in control. And the GA is there, my lord, we have served. That, my lord, we have, my lord, prayed for cancellation of the deed of retirement. I was submitting to your lordship, my lord, there are 5 partners, my lord.
Cancellation of deed of retirement is literally like getting a relief. Like
Yes,
final
that would
relief.
be
My lord,
That is literally like having a final relief. Cancellation.
yes, they have asked for cancellation. Since this has a bearing in the outcome of the litigation, my lord, we have filed this application. So this can be heard with the section 34. We have served them.
But
My lord, it's a
how can this court decide on the cancellation of the partnership?
no, my lord, I tell your lordship. If lordship
The
wants,
subject of dispute would have been the partnership agreement, which has already been decided by the arbitrator. I don't know what is the award, but that would have been decided by the arbitrator.
Learned arbitrator said firm would not be dissolved. So if you want to retire, you retire.
yes.
Yes.
It has to be set aside if that.
Lordship. Now, my lord, kindly, my lord, why I am saying this possibly can be heard with arbitration. There's some bearing. If lordship, my lord, kindly takes up my application once. This has to go to the commercial division. I have no issues, but kindly takes up this application. I think this can be heard. Kindly, my lord, takes up why this is post award. A partner.
Not at all.
My
In
lord,
34, how can I decide this?
my lord, I tell your lordship, why, my lord. I tell your lordship why. Kindly, my lord, comes to the partnership deed once, page 31 of the
But
application.
even whatever is the partnership,
I can,
you are asking me to decide on the merit of a dispute which has arisen out of a contract.
no, out of the partnership. That's why I say.
Of a partnership in 34, how can I decide?
I take just once, my lord, if lordship, my lord, takes up the partnership deed. If lordship says no, I will not say anything. Kindly,
This
my lord,
application is not maintainable with.
kindly, my lord, takes it. I can go before the suit court and but just once.
Have to go before the court.
I can, my lord, just once, my lord. Page 31, if lordship comes to, my lord, why I am before your lordship and did not file any suit. Page 31.
Yes.
Partnership deed, lordship has got it, my lord.
Yes.
Grateful. Now, my lord, kindly, my lord, comes to clause 18 once straight away.
Page.
Page, my lord, patata bolo. Just, my lord, give me a minute's time, my lord. That is, my lord, page 45.
46.
Page 46. 46 is the typed copy, my lord. Kindly, my lord, comes to clause 16. 18, lordship, my lord, kindly comes to, my lord, clause 18. Clause 18 is page 45, my lord. On the retirement of any of the partner from the partnership, kindly, my lord, sees clause 17 once, my lord. Previous clause, any of the firm partner may retire from the partnership by giving 3 months notice in writing to the other partners. Lordship has got it, my lord.
Yes.
Next, on the retirement of any partners from the partnership firm during the continuance of the partnership, the continuing partner or partners shall have the option to purchase the share of the retiring partner and partners in the assets of the business of the following firms. So what they did, my lord, 2 partners, they didn't give us any notice. The other 2 partners, they have purchased. Now, my lord, whether, my lord, it covers this arbitration clause contained in the partnership deed or not. That is, my lord, kindly, my lord, comes to now, my lord, page 47, which contains, my lord, the arbitration clause. I say there is a clear violation of the partnership deed. Now, what happens? There is a violation and somebody raises an issue. Kindly, my lord, sees, my lord, clause 9, clause 18. Dispute arbitration clause. All the disputes, lordship has got it, my lord. All the disputes and differences, my lord, I will read, my lord, from page 48, which is the typed copy, my lord, more legible, my lord. Grateful. All disputes and differences whatsoever shall either during the partnership or afterwards arise between the partner or their respective heirs and legal representatives, or between a partner and heirs and legal representatives of any of the partner touching in the deed or the construction or application thereof, or any clause or things herein obtained, I stop here, my lord. May I pause here for a moment? Or any account. Right now, I am not on that, my lord. I am on the first part. Up till, my lord, obtained. Valuation or division of assets, dates or liabilities, I am not on that. To be made hereunder, or as to, again, any act, deed, or omission, or commission of any of the partnership business or the affairs thereof, or the rights and duties, liabilities of either of the partners under this deed shall be referred to a single arbitrator. So, my lord, this, my lord,
No question of your GA being
my lord,
maintainable.
my lord, very well, my lord. Then that event, my lord, lordship can, my lord, permit me to withdraw because there's a limitation period, my lord. I will file a suit, my lord.
My lord, my lord, just
Lordship
on the
can,
GA1.
lordship can do it, my lord, afterwards, after converting it to the company, because it's a question of jurisdiction.
But maybe also be served a copy, my lord. I've taken
We have served.
instructions.
We
GA1
have
we have
served.
not received, my lord. That's why I'm not.
He's withdrawing it.
Yeah, yes, my lord. If he's withdrawing it,
Learned counsel for the
Yes,
parties submit that the present matter pertains to a commercial dispute. Full stop. Under section
12, 12 of the Commercial Code Act.
Section 12(1).
No, my lord, 12 read with section 2(1)(c).
I think it's section 2, my lord. It's a commercial.
Section 2(1).
He's taking this point 2(1)(c, my lord, the relevant.
The relevant would be
Commercial Code Act.
partnership agreement.
It would
Yes,
be
my lord.
for
In Roman 15.
Roman 15.
Roman 15. Roman 15.
Roman 15.
Let this matter be listed on the commercial side. The
Withdraw করলে অসুবিধা কি? My lord, since my lord, just my lord, thinking aloud, my lord, since I'm withdrawing, my lord, lordship, will it be converted? And
this can be withdrawn right now.
my lord, any day, my lord, I'm really eager to press this section 30.
Let this matter be renumbered and placed on the commercial division side within a period of 2 weeks.
1 week, my lord, if lordship thinks, my lord. I leave it to your lordship.
2 weeks. Let
Very well.
it takes time within 2 weeks.
My lord,
GA1, learned counsel for the petition seeks to withdraw the present application. The same is dismissed as withdrawn.
And my lord, one more additional thing. I do not know about the limitation. My lord, since I have proceeded bona fide, my lord, just wait, please. My lord, section 14 leave, my lord, may be required if it's barred by limitation during this period. Kindly consider the limit.
That you can plead before the concerned civil court. You'll get the advantage. Today, I can't give you that 14.
My lord, I tell you, lordship, subject to correction, my lord, I have proceeded bona fide. I have,
Yes, but that you can have to claim before the concerned court.
but
wherever
kindly
you
add
find
one
it.
sentence, liberty may be given to approach. Otherwise, I'm before the High Court. My lord, unnecessarily, my lord, the 3 years.
Liberty to file appropriate proceedings in accordance with law.
my lord, just two innocuous prayers, my lord. Kindly, my lord. One, my lord, GA1, although withdrawn, my lord, may I be served a copy, my lord, whatever they have
Served,
filed.
we will give
We have
them a
not
copy.
received a copy. That is one, my lord. And the second is, my lord, kindly give.
Again,
My lord, one more innocuous prayer because Mr. Dev is pressing for urgent listing, my lord. On the next day, I do not want to heckle your lordship, my lord, with the fact that there is another section 34 out of the same award filed by us, my lord,
Both can
which
be
is
heard.
AP 167 of 2020, which has also been filed incorrectly in the regular division, my lord. So if your lordship, my lord, kindly permit us.
I give my consent, my lord. Kindly give the number.
It's not listed today, my lord.
I have no issues, my lord.
I can't pass it.
Yeah,
on.
Yes, I
Down my
understand that. Just for getting them
Just let it be listed after 2 weeks.
deeply obliged.
The other one is listed today.
No, my lord,
Not
it's
there.
not in the list. That is why, my lord.
If it was on the list, I would have done.
Yes, my lord. We'll do the deeply obliged.
Grateful, my lord.
35. My lord, I'm for the respondent. My lord, may I
35, I am for the petitioner. I've been appointed through legal aid services.
may I just brief your lordship? This matter was first given to one Mr. Shonji Banerjee, who expired from the ministry. I'm from the Union of India Railway.
Yes.
So he expired, and at that time, a order affidavit in opposition order was
Back in December
given
20.
back in 2022. However, it was prepared, and then the matter came to Mr. Rudraman Bhattacharya as the senior advocate and me. And then Mr. Rudraman Bhattacharya is now also not in the panel. So now all the papers have come to me just 2-3 days back. And also the officer who was appointed to affirm the affidavit has changed. So I have now prepared the affidavit and he will come today or tomorrow to affirm it. The changed officer, my lord. So I'm just praying.
Am I concerned with all this?
No, my lord, this is
the court concerned with the issues which is being faced by the department? We are only concerned with the fact that why you have not filed it.
yes, that is why it's not been filed, because now
That is no ground, madam. Sorry.
no, my lord, I have now that affidavit has been prepared and that it has to be affirmed by the new officer.
Should have done it long back.
My lord, because the papers were not with me. I am reappointed again now.
I'll impose a cost on the department.
My lord, may please consider this.
I'm not concerned with these.
Give me 2 days.
I'm not concerned with these things at all.
My
None of the concern of the court. It is between you and the department. How the department handles this brief, it's their problem. And how you coordinate with your department is your problem.
My lord,
it is not this
my
court's
lord,
problem.
I have put everything into place now. My lord, only 2 days.
If you want me to say that you have done a great job,
my lord,
sorry.
I'm not
I'm not
just praying.
concerned.
I'm praying for 2 days time to get this affidavit.
When was the directions passed for an affidavit?
My lord, in 2022.
Then why shouldn't I impose the cost of 2 lakh rupees on the department to file this?
My lord, because the person expired.
I don't care, madam. If your department works on one person, you are representing government. It doesn't work on one person.
My lord, then there was a
Explain the delay
change
to
of advocate and then further change of advocate, my lord.
I'm
My
not
lord, I'm
concerned.
urgently, I'll leave it to your lordship, my lord, but I'm urgently praying, give me 2 days time, I'll get the affidavit affirmed. I have called them, I have,
Before this matter was listed, you should have done that, madam. When were you engaged?
my lord, few days back, I have had a conference, I did not even have the papers.
When were you put on the panel?
My lord, I am in the panel for the last 3 years, but
if the department wakes up at the last minute and contacts a lawyer at the last minute, is it our problem?
My lord, there was a change of advocates seriously, my lord.
You file your affidavit with a cost.
Since 2022, my lord, hand to mouth.
1 lakh rupees cost on the department.
My lord,
Let Railway the rich organization.
my lord,
Let them
kindly,
pay 1 lakh rupees.
my lord, kindly this thing.
Every time, my lord, we are filing fresh affidavit of service, my lord. May I please?
Direction.
My lord will please consider this.
No, this is too much.
My lord, I have called them today afternoon to affirm it. My lord will please consider this.
This court-wide order dated 27th September 2022 had directed the respondent, Indian Railway, to file their affidavit. This court was ordered
last chance,
July
my lord.
2026 had observed the same. Full stop. You are Upasna Shaw.
Sanjukta Gupta.
You didn't appear on 7th July.
No, my lord.
Till date, no affidavit in opposition has been filed by the respondent. Miss
Sir, as a last chance, I'm praying.
Is for 2 weeks' time to file her affidavit in opposition. Full stop. The department is required to explain the delay from the year 2022 till date for not filing the affidavit in opposition by way of an affidavit, personal affidavit to be filed by the GM Railways. Who will be the person concerned?
My lord, give me a moment.
Since 2022, my lord, I am suffering. Not even paid for the work, my lord. And point is, My lord, only unilateral appointment.
Just a minute.
My lord, one Himadri Shekhar Roy, who is
Who's the head?
divisional signal, a senior divisional signal and telecommunication.
Madam, who's the head of this organization?
GM Railways.
GM Railways. Which division?
Signal and telecommunication.
Signal and communication. Learned counsel for the respondent states that the GM Railway is the head of the division pertaining to the present matter. Full stop. Let an affidavit be filed by the GM concerned explaining the delay in not filing the affidavit in opposition from the year 2022 till date. Full stop. This court might be constrained to impose exemplary cost on the department, on the respondent, if the reply is not satisfactory. If the delay explained by the department is not satisfactory, I'll impose a cost of 5.
My lord, only one thing, my lord.
Good.
The petitioner also sat, and only in July, sometime first week of July, it mentioned the matter.
You forget about the petition, you'll be concerned about
They have
yourself.
been mentioning since long, and there is a plethora of affidavit in service, which proves otherwise. I'm grateful, man.
Affidavit service taken.
Grateful.
वो लिखवा देना फिर she seeks further time of 2 weeks to file an affidavit in opposition as well as the personal affidavit of the GM concerned explaining the delay in not filing the affidavit in opposition from the year 2022 till date. List after 3 weeks.
Lord 36. My lord, in item number 36, my lord, Mr. Farhan Ghaffar appears for the respondent, my lord. I was only praying if not today be granted, my lord. He has not come to court today, my lord.
There's a slight confusion, my lord. My learned friend says he appears for the petitioner. But my lord, the Wakalatnama, which my lord, the original, my lord,
Not today, sort it out.
my lord, I had instructions that the matter is getting settled. I was requested to seek a month's time so that the parties can settle and come back.
Come back next week with the right information.
Very well, my lord.
With the
Very
right
well.
instructions.
We'll sort it out and come back.
37.
Lordship, I appear on behalf of the respondent in this matter. Lordship, in the last occasion, the petitioner has sought time to take instruction on the point whether they will withdraw the matter because they had taken the point that they have not been served with a copy of the award. I had Lordship satisfied your Lordship on the point that it had been served and they had filed the 34th beyond the statutory time limit.
None appeals for the petition, dismiss and default.
Grateful, Lordship.
Malaj, I appear on behalf of the respondent in item 38.
Praying for not to do.
Why?
The advocate on record is out of station.
Malaj, I wish to file an affidavit in opposition. There's a fresh section 34, no scope for any interim relief. Their claim has been dismissed by the tribunal.
We'll see it next week.
Right.
Well, on my section 34 application, my lord, the affidavit service may be filed, but this has not been served. It's showing insufficient address.
Okay.
Now that, yes, we'll do that. Lord, one more thing, my lord. This application has been filed on the 119th day, my lord. The explanation we missed out on. Can we file a supplementary? That I'm seeking a leave to do that. If that, what happened is because of these transitions and panels, things got delayed. So it's filed within 120 days, but not within 90 days. So
Supplementary affidavit explaining the delay.
I'm sorry, my lord. Yeah, that happened.
Explain the delay here itself.
That paragraph went off. The lordship allows me. I will.
Supplementary affidavit explaining the delay. No, sorry.
Oh, it's not
Put that
required.
with see on the next.
Very well. This affidavit will be kept on record.
What's the point?
Yes, madam.
Service is not complete. Not today.
Okay.
My lord. My lord, item number 40, my lord, I am appearing on behalf of the.
No, I'm for the respondent one. Well, it should be a commercial matter, should be of commercial division. Anyway, they should be present, but it should be a commercial division matter.
None appears for the petitioner. In the interest of justice, adverse orders are deferred. We'll keep it after 2 weeks.
I leave it to your lordship because
Best after 2 weeks.
Not today, your lordship.
My lord, I am appearing for the respondent. There was a direction for me to take instruction, but if my learned friend is taking time, my lord, I have no objection.
Not today, your lordship.
What instruction you have to take?
My lord, this basically it's a my lord unilateral award, my lord.
Yes, yes.
So
It
there
has
is
to go. What
yes, my
instruction?
lord. I have taken instruction. Your lordship has directed me to take instruction whether I am agreeable to setting aside and appoint a fresh arbitrator here, my lord. The only problem to this, my lord, the arbitration clause is that arbitration seat is Mumbai and also, my lord, the jurisdiction is Mumbai. So for to that, my lord, I don't have any instruction, but my lord, our award has to go. I don't
What
have
has to
any.
go? Then after that, whatever it has to be done, it has to be
Yes,
done.
yes, my lord. What if my client has any right? My client will take as steps as.
Correct. Yes.
Same for not today for the.
Not today, not today.
Very well, my lord. Great.
Very good.
My lord, I appear for the petitioner. My lord, Mr. Anirban Rai was submitting on merits. My lord, it fell from your lordship because the principal amount is only of 5 lakhs. And we had deposited the money with the court learned registrar. Now, your lordship had observed that if the parties could settle it. Now, my lord, I have spoken to my client. They are agreeable to pay 8 lakhs. 5 lakhs is the principal amount along with that 3 lakhs. Now, what they are asking is they are asking the entire money which you have deposited. That is 16 lakhs. So, my lord, if they are agreeable to, they are not here today, my lord.
Not today. None for the parties. In the interest of justice, adverse orders are deferred. Monthly list of adverse orders are deferred. Monthly list of August. September.
ব্রিফটা ওদের একটু ইয়েটা দাও, জাজমেন্টস গুলো দাও, পাঞ্জাব হরিয়ানাটা বার করতে পারো। Well, item number 5, my lord, I am for the petitioner.
Yes.
My lord,
I am appearing for the respondent, my lord.
What is it?
well, this was an award under the National Highways Act. Well, the arbitral proceeding was venued in Calcutta, but the subject matter of the dispute was in Howrah. So the question that fell from my lord and was raised by my learned friend was that this court doesn't have the jurisdiction, like in terms of territory. My lord, I endeavored to convince my lord. My lord, I am carrying few judgments. Not, I'll just ask them to bring the copy of it. My lord, the principle is, if my lord can recollect the Shashua's principle. My lord, post Balco, how Balco has evolved. My lord, thereafter, my lord, Justice Nariman's judgment, which has crystallized the concept of Shashua's principle, which says that when the seat is not expressly mentioned, then the venue becomes the seat. Well, that is the principle. Well, I lay those judgments also. Well, 2021, 2019, and my lord, there is one also of Punjab Haryana High Court, identical case, my lord, very similar, my lord, which actually says that I could not have filed it at Howrah. I had to file it here because the venue was here, my lord. Well, admittedly, the venue was here.
All right, show me.
একটু judgmental copy গুলো তো আনতে পারছো? Well, I've just, well, the matter was taken. I've just asked them to get the copies of the judgments. I have all of it. Well, can I just hand, if it is possible, my lord? Well,
Copies of the judgment. Give her the copies of the judgment. If whatever you're relying upon.
well, I'll just get it, my
Why
lord.
at the last minute? Didn't you know that matter was listed?
My lord, my lord. Well, I take it.
Not today. Why waste my time?
My lord, may I indulgence, my lord? If your lordship can you fix the date, my lord?
Not today, next Tuesday.
I will.
Very well. Thanks. Well, I'll get it.
My lord, I am appearing on behalf of the petitioner, my lord. I'm the Mr. I'm proposing the name of Mr. Ghoshal, Rizu Ghoshal, senior advocate, as an arbitrator, my lord.
Who's on the other side? Where's Mr. Pandey? Not today. With the consent only I can want.
Even Lordship, I am praying for short password on behalf of the petitioner, Lordship.
Not today. Pass.
Well, I am for the respondent in item number 8.
That I will not appear with that formula, the person will not asking for setting aside of the oath.
Very good. Yes.
Yes. Now, my lord, kindly have a look at the award in question.
Readings are complete?
Yes, readings are complete. Page 15 is the award.
Let me come back. We'll hear it, huh? Mr. Ghosh.
Lordship.
Mr. Yes, you are Mr. Ghosh. You are Mr. Ghosh?
Yes.
To come back.
Can I tomorrow? I'm on legs from 2 o'clock.
I was so happy at least.
12:30. 12:30.
I'll just come back.
Oh, I thought Lordship is. I'm very sorry. Well, I am here.
But will you be able to finish it?
I have 10 minutes submission to make.
That's it.
That's all.
The application for setting aside, well, 3 points, Millard. A, unilateral appointment by the claimant. B, Millard, it's a question, Millard, going root to the matter, the question of bias, because Lordship will find, Millard, from the award that, Millard, the address of Millard, the Millard arbitrator and the claimant's advocate is the same. C is, Millard, it relates to a partnership disputes. Millard, in a partnership dispute, Millard, there can be, Millard, dissolution under section, Millard, 43 onwards, Millard, going to 48 valuation. Prayer was for appointment of receiver and the receiver to continue in an interim measure. And, Millard, on the verification of the statement of claim, it is not been affirmed by the claimant. These are the 4 points, Millard, going to the root of the matter. Millard, the award was not served, so it's not executable to me, not denied by them, Millard, at least I find. Millard, I participated in the proceedings. Ultimately, on 4th of November 2025, I applied for the certified copy. The arbitrator gave me the certified copy, which is page 14 of your Lordship's brief. If your Lordship takes, Millard, the award in question, which is, Millard, was given to me under the cover of the letter of 17th of November 2025, I received on 14th.
So this is your letter asking for the copy.
Yes. Millard, letter asking for the copy is at, Millard, page 14 of your Lordship's brief.
Correct. Page 14.
Millard, may I place it?
As per our
I
communication.
write to you.
Supplying
Was
you.
reference to the communication exchange between us, we hereby kindly arrange and provide certified copies of the entire arbitration proceedings concluded in the matter, including the pleading, submission, interim order transcripts, evidence, and the final order commencing from the initiation of the proceeding. The said documents are required to be our official and legal records, and further to exercise our legal rights. Millard, we have asked, now kindly take the award. Kindly have a look at the award, which is the next page, Millard, page 15. Millard, arbitral award delivered by Gopal Chandra Das, having its office at 10 Kiran Shankar Roy Road, 2nd floor, Kolkata 33, room number 33, Kolkata 1. Now, unilateral appointment, Lordship will find. Millard, kindly take paragraph 2 at page 20.
Yes.
Millard, I have been requested to act as an arbitrator by the claimant after the maybe vide, Millard. It's written after. Vide, the letter dated 21/7/2023. Upon receiving the request to act as an arbitrator, a request was made by the claimant to cause publication in the leading dailies, one in English and other in Bengali. Intimate the dates of the meeting in another matter. The same respondent was not represented despite publication in dailies. They are not represented. I neither collected the award. So, Millard, he goes on. Now, Millard, kindly have a look at page 37 once, Millard. The verification part of the SOC begins at 34. Millard, it's in relation, if your Lordship takes, Millard, in relation to a deed of partnership dated 29th of January 2020. And if your Lordship straight away goes to 37. I, Chad Muhammad, the claimant. Millard, the claimant is not Chad Muhammad. The claimant is someone else. It's a company. Above named do hereby declare that the statements contained in paragraph 1 to 11 are true to my knowledge, and based on record, I sign this verification on the blank day of September 2022 at the chamber of my advocate at same address, 10 Kiran Shankar Rai Road, 2nd floor, room number 33, Kolkata 1. Same to same, Millard. And look at the prayers, Millard, page 36. It's a partnership dispute. So, Millard, dissolution by court or by the arbitrator. Section 43, Millard, to 48, Millard, of the act in question. The prayer, page 36. A fit and proper person be appointed as a receiver in respect of the property in the given schedule below. An award to the effect that if the respondent is not willing to go ahead with the partnership agreement, There cannot be any enforcement of a partnership agreement in specific performance. And the claimant has already invested valuable time and efforts to make the property commercially viable, then he be compensated adequately for such effort being made. How can this be the final relief? Now, my lord, on the point, there's an expiry of mandate also. When I moved it on the first date, Lordship said, Lordship's view was there's a recent view of the Supreme Court. Expiry of the mandate, ipso facto, doesn't render the award, my lord, unworkable or liable to be set aside. In fact, Lordship told me this. I went back, my lord, this is the law, but my lord, one has to apply for the extension. In case this has not been done, my lord, dates, my lord, statement of claim, Lordship may note it, my lord, was filed on 28th of September 2022. My lord, the SOD, that is the statement of defense, was filed on 25th of April 2023. That's page 95. It's recorded in the minutes. Kindly have a look at the minutes at page 95. The Lordship is kind enough to come to page 95. My lord, has Lordship found? Today, the learned advocate appearing for the respondent submits that he has served a copy of the statement of defense upon the advocate appearing for the claimant. The advocate for the claimant acknowledges receipt but submits that he needs instruction from his client and he has received instruction, has received the statement of defense at 2 p.m. Upon the prayer of the advocate for the claimant, the matter is adjourned and liberty is given to the advocate for the claimant to file rejoinder, if any, within 2 weeks from date. An advance copy has to be served on the advocate on the next day. Now, my lord, kindly, if Lordship looks at my SOD, Lordship will take my SOD in question. 58 starts at page 58 and ends at page 65. There is no counterclaim. So it's from the date of the SOD, my lord. Counterclaim. Kindly take, my lord, page 65. This is, my lord, what I have prayed. I have paid for dismissal of the claim in question. Now, my lord, if your lordship takes the date in question, the mandate expires on 16th of June 2024. If rejoinder is considered.
Rejoinder, they have filed it.
The rejoinder is, my lord, page 99.
I've got it.
Hello. Yes. So, my lord, 16th of June 2024, if your lordship takes the awards, gives him the benefit of doubt of the rejoinder also, because according to me, rejoinder also doesn't extend the situation because there is no counterclaim. But give him the benefit of doubt. It expires on 16th of June 2024. The award is 4th of November 2024. No one has applied for extension of time. The award has been passed.
4th of November?
4th of November 2024 is the award. Kindly, my lord, takes, my lord, the award, my lord, which 4th of November 2024. If your lordship kindly have a look at the award, kindly takes, my lord, page number, running page 32, the last page of the award. It's 4th of November 2024, place Kolkata. So even if lordship takes a very, my lord, lenient or charitable view, my lord, the mandate has gone, no one has applied for extension. I kept it last because lordship gave me the judgment. You consider that and come. In another matter, lordship also told me, my lord. But one has to apply. Prior to the passing of the award,
Veera Swami, Rohan Builders, all that. Veera Swami, Rohan Builders.
Yes, absolutely. Lordship gave me the judgment on the first. So, my lord, 3 points. My lord, first, my lord, it's a related party. Second, my lord, is, my lord, unilateral appointment. Third, my lord, is, my lord, it's beyond mandate. Fourth, my lord, it cannot be granted. And lordship will ask me a question that, my lord, why I have not moved into the commercial division. Lordship will ask me the question. Lordship has the power to transfer. Now, Supreme Court says, my lord, you shouldn't dismiss, you should transfer. Now, lordship can do that because, my lord, the award doesn't have a specified value. So, unless twins test is satisfied, I cannot transfer it. But if Lordship wants to hear in the commercial division, Lordship will transfer it. I have the judgment, of course, in this sort. So these are my respectful submission, Milord. There are judgments galore. If Lordship calls upon me, I can give. But this, Milord,
I have only one submission that my senior friend already said that this is a commercial deal.
Exceedingly commercial division.
Milord,
I have no
cannot be transferred. It has to be disposed of and then it could be filed. I will just provide the circular, Milords. This is the
even the circular. I think the even the rules here.
There is no specified value.
There is no specified value.
Milords, this is a commercial dispute.
Specified value.
And if it is dismissed, then the limitation will act on him.
Lordship, Supreme Court ওটা দেখাও না।
Milords, in the point of limitation also I have something to
commercial,
say. Kindly
commercial
come to
Supreme
page
Court.
number 14.
You have a soft copy.
Kindly come to page number 14, Milords.
Yes.
This is the first paragraph. This draws reference to communication exchanged between us.
Yes.
Plus, this is how it is been applied that this is the first certified copy.
Yes.
There has been no plea, no document that I have not received any certified copy or signed copy earlier prior to this certified copy.
To prove it, you prove it that they have received a certified copy.
I don't, Milord. My understanding is junior to me. 1 to Milord 8 is not dealt with. This is 1 to 8 is dealt with. Rest Milord on this is not even dealt with it. No denial. And Milord, it operates Justice Sarkar's judgment. There's a coordinate bench's judgment. Milord, this invalidity will go to the root of the matter. In a 47 also this will lie with this invalidity. Milord, it has to be served on me. Justice Kavi's judgment of 2010. And Milord, this is YD transport judgment of Justice Sarkar, Milord, of a coordinate bench, Milord. I have a copy with me.
That's on the point whether it was served or not. I have to check it, Milords.
What will
Paragraph 68 and 69, Lordship.
In your affidavit in opposition, what have you stated?
That I agree in that.
Then
68 and 69.
Unimprovise.
Because, but Milords, the point of maintainability is always open, Milords.
Absolutely open, sir.
May I just come after checking whether it has been served or not, whether I have any record, Milords? That point I.
Wasting the time.
Reply is already filed. He has not dealt with it. And Milord, I have to be served.
Milords, not today. On the next date, I'll just one day.
আগেই বলতে পারতেন।
Why are you wasting my time? That's why
wasting time to waste হচ্ছে। I'm agreeing to go to a arbitrator of it. Let him take a name. Why Milord waste? It will be for
ground only. We can set it aside.
Set aside.
Get a
Milord,
new
we go back to
arbitrator,
someone
go to
else.
the
Let
new
us take the
arbitrator.
procedure.
I'll take the instruction, Milord.
We'll set aside and we'll go, Milord. Where is the
Please come next time, next week, with the instruction. We'll set this aside on the ground. It's a unilateral appointment. We'll appoint with the consent of the parties a new arbitrator. Refer it to them.
Any mid-level senior Milord, Lordship will go.
Both of you can come back with the.
I Milord said this will haunt him for all times to come. 47, everything, Milord.
Better get this set aside and.
Lordship will consider paragraph 68 and 69 of the coordinate. That's Milord Justice Kabi's judgment, Milord sir. Huh? My Lord, a নিজের decision আছে তো. Yes, Lordship. Yes, I have also carrying Milord. Milord, in one of the matter after I have been designated, just court 16 told me once that my judgment don't cite to me at first. You cite that to me at last. I may not be bound by it. So I am very apprehensive. You always come, you show my judgments, but if I may not be bound.
Please always show my judgment.
Yes, I'll definitely do. I'll do that. Yesterday I was hearing the 29A, Milord Lordship. Yes. I was watching Milord for the next matter 29A. After the award, one of the arbit, very interesting.
It is very interesting because there, this Rowan Builders and Virasamy will not be applicable.
Correct.
Because
Mr. Kaur has a perfect point for setting aside the award.
Yes.
But 29A will not lie.
A will not. That's what I was telling him. And you know,
arbitrators nowadays has to be very careful.
Whoever, suppose, let us assume, I extend. And if the arbitrator doesn't pass an award.
Doesn't pass the award then his right of setting aside is prejudiced by your Lordship's order.
It doesn't help him.
I was thinking that, Miller.
That's what I told him. Now, how does it help you?
It doesn't help him at all. This is a perfect ground to set aside on the first day.
So I think that appealed to him, and
Yes.
He'll come back.
Isn't campaigner, Miller? He'll come back with that. Grateful, Miller. Great. Next week?
Next week, next week.
Today?
We'll finish it next week. What's the
Yes,
point
yes.
of-
Any date keeps it. Miller, I'll go to an arbitrator. Great.
sorry.
Please item number 9. I appeal for the respondent, my lord. I have a preliminary objection. This ought to have been filed in the commercial division.
Your Lordship, I'm appearing on behalf of Miss Amrita Pandey, Your Lordship. She's legs in another court, Your Lordship. I'm praying for not today, Your Lordship. Obliged.
Not 10. 10 is also the same.
Same.
Obliged.
11.
11.
Mr. Pandey, there was one matter. You were not there.
Item number 6, man. I have other side is informed. They have given name from name.
Next,
I have to take instruction next week. I will.
Next.
They have given informed me the name of the.
Item number 11 to 15, my lord, I am praying for not today, my lord.
Why?
Mr. Priyanka appear in this matter for the petition. No,
Not today.
also, my lord, 17, 22, and 23.
Wait.
Sorry, my lord. Sorry.
You are appearing for whom?
Petitioner, my lord. Petitioner.
Item 16.
Not today. No point.
16. Your Lord, 16 I'm present.
Yes,
Your
yes.
Lordship, I'm appearing on behalf of the petitioner.
Yes.
Here's the affidavit of service.
16.
16, 1 6.
Monthly list.
Yes.
Your Lordship, can the hearing be taken up the next week because my learned seniors are into the legs in the different
Come
court.
back with the affidavit of service next time. Not today.
17, I'm also, my lord, praying for not today, my lord.
I appear for the respondent, my lord. The point of jurisdiction. I took the point of jurisdiction, my lord. The agreement says that it will be the arbitration is the arbitration took place in
Appointment, my lord.
arbitration took place in Bombay, my lord, and the agreement also says that the jurisdiction of
Unilateral appointment.
Yes.
but my lord jurisdiction.
So what?
Well, that I understand. My lord. If my lord takes suo motu cognizance, I have nothing to say, my lord. But the jurisdiction, this court doesn't have a jurisdiction. They have to file before
Alright, not
Bombay High
today.
Court, my lord.
Yes, not today.
Monthly list item number 18.
I am appearing on respondent, my lord. I have only the appearing I don't know but I have not received the copy of the application. I am appearing on Sriram Asset Reconstruction Company, the respondent.
Not today.
I will write a letter to them.
Item 19.
Lordship, I am appearing from the petitioner. Lordship, in this matter, petitioner did not receive any arbitral proceeding copies. And
You are doing or some senior is doing?
that
Are you the
Yes.
senior? There's some senior? Not today.
Item 20.
Your Lordship, I am on behalf of the petitioner. Your Lordship, praying for not this week.
Not today.
Monthly list item number 21. AP 99 of 2026.
Not today. दिखाना क्या है इससे 21 दिखा
Item 22.
एक मिनट
Item number 21.
Not today. Set aside.
At 22.
I'm putting for not today, my lord.
Not today.
23.
23 also.
Not today.
Keep left.
Item section 34, item number 24, monthly list.
24, my lord, I appear for the petitioner. Pursuant to my lord's last order, I have served upon the respondent. The respondent is in liquidation. I have served upon the official liquidator. Here's my affidavit of service, my lord. They have received.
Then what will happen?
Lord, on a previous occasion, a learned counsel had appeared, but since then she has been elevated to the bench. Thereafter, they have stopped appearing.
You have to find out who the RP is.
Yes. I will try and find out, but since their office has been transferred to Rajarhat,
What can be done there?
Lordship.
It's in liquidation. What do we do?
I'm led by Mr. Dev. I will take care. Great.
25.
Not today.
26.
25, not today.
24 minutes.
Yes, Mr. Dev, he's saying they're in liquidation.
Yes, Milord, unless Milord we serve thrice, Milord we serve. But
What do we do then?
again a service because I can't.
That's what I'm saying. But
Lordship has passed an order for service.
No.
Otherwise, Milord, last orders of Lordship, every time we have complied with Milord. But since the company has gone into liquidation, being represented by the official liquid, they are not come.
The official liquidator has to be served.
Yes, so Milord, kindly Milord pass an order again directing me to serve. Otherwise,
Learned-
Milord, no way if I can press
Learned
before the
counsel,
Lordship to
learned
take it
senior
up.
counsel for the petition states that the company has gone into liquidation. Let the service be effected on the official liquidator within a period of, he seeks and is granted liberty to serve upon the official liquidator within a period of 3 weeks, list after 4 weeks.
And Milord, may the affidavit of service be taken on record which contains the service, Milord, because we have done it complying your Lordship's order.
Affidavit of service. Speaking on it.
A difficult situation, Milord.
Difficult situation.
Very
That
difficult.
can be done also.
No, I can't press for Milord taking up the matter.
That's what I was telling him.
Yes, yes, absolutely. Grateful, Milord.
Yes.
26 and 27. But I appear for the petitioner in 26. Your Lordship will find there are two APs.
So obviously they have to be.
Your Lordship, I'm appearing on.
You are appearing for Hindustan.
Yes.
And you?
I'm appearing on behalf of Union of India, led by Advocate Nandalal Singhania. Kindly, I'm praying for the matter to be fixed at 2 p.m.
Fixed at 2 p.m. You'll argue it. We'll
My
have it
finger
at.
is not well.
They'll do nothing. They'll come and take date. Not this week.
Lord, kindly keeps it in the daily list. Not it's the 2009. Your Lordship sees it's the 2009.
तो daily list में डाल दो इसको. 2009 award.
Yes, Milord.
ये जो अभी हम we are planning to hear the matter now. Thursday या एक दिन 34 रख रहे हैं ना. We want to hear Thursday कर लेंगे. Next month. हाँ, so next month is right around the corner.
I know, but I can understand your lordship's predicament regarding the a very heavy list. After 2. So that in that case, not Tuesday, then it is. Not today.
Simply not today, right now. Madam, come here. This is also Union of India. Inform the department.
Your Lordship.
Item 28, make a note of it. It's Union of India. Inform your
26 and 27.
No. The Union of India. Nobody is representing Union of India.
So inform your senior.
Kindly, I'm praying for.
Yes, not today, but inform your senior so that.
That-
Yes.
He is representing.
Take the details of the case so that you can inform.
He's also there. Well, she can take instruction.
But
I have item 30.
he won't. You take care of it.
I'll.
Know what to do.
Yes, I'll have to.
Yes.
But is my application. I'll talk to her. I'll do the needful.
Not today.
Great.
Rest after lunch. लंच के बाद क्या है एक
Lordship, I'm appearing for the respondent, my lord, in this matter, my lord. This is ideally a commercial.
But this execution is not maintainable because, my lord, it is filed in the
on the other side.
Lord, I'm appearing on behalf of the petitioner.
Yes.
Is their application.
You are ready?
Not my application.
Not my
My lord, I'm not. I would like to take a short pass over.
Who's there? Who's leading you?
Their application.
Your application.
Yes.
My application, and
The indicate.
Why he is saying is their application?
my lord, I deeply oblige, my lord. It's my application.
Who's leading you? Who's the lawyer?
Mr. Mukherjee, Shukrit Mukherjee is leading me.
Not today. Let the lawyer come. He doesn't even know him.
It's a substitution application in connection with an execution application. Execution filed in 2018 after the coming into force and the notification of the Calcutta High Court establishing the commercial division. So this is really not a pending proceeding under the meaning of section 15, which can be transferred. So this should be dismissed. I'm just giving him the point bullet so that he can.
Good, you're giving him the point. All right. Not today.
Lordship, I'm just praying for an adjournment because this actually deals with the law point which we are arguing in item 43.
41.
In 41.
Here, 41.
41, Lord, there's a condonation of delay application. I'm opposing this. And Lord, I'll have the similar
Mr. Thakkar in this matter.
prayer which Mr. Gupta has made.
Affidavit.
Lord, in the meantime, Lord, may I use an affidavit? Will
For what?
because this is a condonation of delay of 1,000 days delay. I'll use an affidavit to explain.
This is exactly the point which we
Lord,
are
me
arguing
kindly,
in
Lord,
item
gives
43.
direction, my Lord. We'll file affidavit.
Let us reply, my lord.
Your application.
My application.
And also, my Lord, that this matter is has to be dismissed because this is the commercial division matter filed after, my Lord, the constitution of commercial division. Apart from condonation of delay.
So there's a restoration.
Yes.
Restoration after 989 days.
After 989 days. Lordship, I believe it is the same thing. It had to be specially assigned. It was not assigned.
I'll file an affidavit, my Lord. I'm contesting this application.
Learned counsel for the. This is an application filed by the respondent seeking. This is a restoration application filed by the respondent. Full stop. The respondent has filed this application with a delay of 989 days.
But not by respondent, by the petitioner award holder.
Lordship, award holder.
Oh, you're the award.
Yes.
I think we should stand here.
You're standing on the wrong. Learned counsel for application filed by the petitioner for restoration. With a delay of seeking condonation of delay of 989 days in filing the said application. GA. Restoration. For restoration. Seeking condonation of delay of 989 days in filing the said restoration application. Learned counsel for the respondent opposes. Learned counsel for the respondent states that the present application seeks and is granted. 2 weeks.
2 weeks.
Seeks and is
Lord,
granted.
Lord, can it be 3 weeks because
3 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. List after 4 weeks.
Lordship,
I'm seeking extension of time to file my affidavit of asset.
Lord, I appear for the
Yes.
Lord, I appear for the award holder, my lord. My lord, repeated directions on the award debtor to file their affidavit of assets, my lord. They've not filed their affidavit of assets, my lord, on the
Yes,
12th.
Miss Pandey, what
Lordship,
happened?
I'm seeking 2 weeks time to file my affidavit of asset or I'll deposit the amount before the learned
There is no
registrar.
application, my lord, taken out.
I'll place on the bank details by which I'll place it before the registrar because my 34 is pending. I have not filed any 36.
Lord, may I only say one thing, my lord?
Learned counsel for the respondent award debtor seeks and is granted one last opportunity to file his affidavit of assets within a period of 2 weeks. She assures this court that in case the said affidavit of asset is not filed, she will deposit the entire awarded amount before the Registrar General.
My lord, I must indicate, my lord, there is no 36 application taken out.
She's making a statement here. I'm recording.
Either I have to secure it or I have to place it.
Bole che, last opportunity.
Just after 3 weeks. After 3 weeks.
Yes, my lord.
That's why I've recorded that. Yes, madam, you tell me. Tell me what is your concern.
No, your lordship. I was just instructing as she is leading me. I just instructed her, your lordship.
So what's your
Only thing-
concern?
No, your lordship. Only only one thing, your lordship, is section 34. As they have stated that they filed that section 34 application. Your lordship, I was only submitting if they're taking if that it is not yet listed running in the
That's why I've
it's running in
recorded.
the monthly list, your lordship.
That's why I've recorded that they'll secure you.
Your
Lord,
lordship.
my learned senior friends, only, my lord, concern is that the direction may be made preemptory, my lord. That's all.
Yes, because twice they have lordship. Only
My
that
lord,
was
peremptory direction,
I've
but
done.
your lordship has recorded the last opportunity, my lord. I'm grateful.
only that.
Next.
Hey, Nam Pradeep.
Mr. Lahiri, they have taken time. Mr. Lahiri, Mr. Siddharth Lahiri. There one more matter was there. They have taken time in your name.
I know, I was on my deck.
Just ensure that
I was on my deck. But on second
no
level,
reply has not been filed for a very long time.
I know, I understand.
Yes.
But in this, my lord, we've been again served with, this is the third supplementary affidavit. So
This-
I don't know, my lord, there was no leave also.
I,
One after the other, my lord, they're filing supplementary.
I'll indicate why. This is in response to the report which your lordship called for, which was given an inspection of. So it's only dealing with that, nothing else. If your lordship wants me to file, I can. If permits me to file, I can. Otherwise, I can argue also.
You argue? Yes.
My lord, your lordship called for a report. This pertains to whether the matter was assigned
Assigned or not
after being
assigned?
released. Kindly seize the report once, my lord.
কোর্টে আছে রিপোর্ট কেউ
ও,
পায়নি।
বলেছো
স্যার রিপোর্টটা
এরা তো জানে রিপোর্ট
আমি বলছি স্যার কেউ কেউ পায়নি
ও
রিপোর্ট the matter was sent to the regulator which is the petition
Good.
and 2015 to the regulator.
Yes. Yes.
My lord, here, my lord, what we find is that, my lord, after it was released in 2016, due to personal reasons, this has never been assigned. So, my lord, in all likelihood, what had happened was, my lord, it appeared in the warning list. Though, my lord, we had shown the provisions of the original side rules that there is no warning list, perhaps, my lord, for execution proceedings. It's only warning list which can be there in suits. So, and thereafter it appeared before a bench, which is otherwise a bench which had the determination as such.
Yes.
So, my lord, now when the matter was released,
Then, my lord, it was required to be assigned. And, my lord, if it is not assigned, and then, my lord, the order which has been passed for dismissing, my lord, that possibly becomes without jurisdiction, my lord, because without the assignment, my lord, only on that point, my lord, two judgments, my lord, that the Chief Justice is the master of the roster, and it's for the Chief Justice to assign or manage the roster, my lord, only for that purpose. 2018 টা 2018 2025 SCC online SC 582 para.
And 9 is the most important. 7 to 10.
কপি আর কপি আছে দুটো না একটা কপি একটা আমার কাছে 25 আচ্ছা একটা কপি and we'll kindly have a look at paragraph 9, my lord. In the light of the law laid down, has your lordship got it? In light of the law laid down by the High Court itself in Sohanlal Bed, as approved by 3 judges bench of this court in state of Rajasthan, which has subsequently been approved by a constitution bench campaign for judicial accountability, as well as Rule 26 Supra, we hold that any order which a bench comprising of 2 judges or a single judge may choose to make in a case that is not placed before them or him by the Chief Justice of the High Court or in accordance with the Lordship's directions, such an order is without jurisdiction. In other words, an adjudication beyond allocation is void. And as such, adjudication has to be considered a nullity. It needs no emphasis that the Chief Justice of the High Court, being the primus inter pares, has been vested with the power and authority to set the roster as articulated in Sohanlal Bed, and such roster is final and binding on all the companion judges of the court. Therefore, the order dated such and such and the impugned order are without jurisdiction. But this we are, my lord, marrying into our facts in the sense that when it was discharged, released, when it was released on account of personal ground, my lord, then it was directed by that same order to be placed before the Honorable Chief Justice for assignment. That never happened. Only one other judgment I shall trouble your lordship with. On this one, it's our High Court's full bench judgment.
This doesn't really help you. How does
we were under our point is, my lord, subject to what falls from your lordship, is, my lord, that the assignment had not taken place. When it was before the Chief Justice and the order specified that this has to be assigned before the Chief Justice, that assignment has not taken place. That is what we came to learn from the report. Right. So, my lord, if that be so, then, my lord, the matter has not appeared as a specially assigned matter before any bench. In that sense, otherwise, I am not for one saying this bench did not have the determination to take up execution. That is not my submission, because that bench had the determination to take up execution. But, my lord, because it was directed in the release order that it has to be assigned, that is my lord, we were trying to draw an analogy, though facts not identical, but drawing analogy that since the Chief Justice is the master of the roster and since it was directed that it should be placed before assignment, that is why. Otherwise, exactly on facts, my lord, this is not. But I am trying to borrow the principle, subject to my lord's interpretation, of course.
You're borrowing the principle to the extent that since
I'm sorry,
there was a direction, you're borrowing the principle to the extent that since there was a direction,
yes,
that it should go before the chief and
for assignment.
Yes.
Only for that.
Yes. What else?
Into that.
সেটা তো বটেই, but বলছি কেটা কেন?
Go aside.
In this judgment, your lordship would kindly have a look at para 24, paragraph 24 and 25 at pages 11 and 12.
While the High Court has the jurisdiction to admit and dispose of a matter, individual benches, either sitting singly or in a division bench otherwise, can assume jurisdiction over the subject matter only in accordance with the allocation of the business of the Honorable Chief Justice on the principles of Master of Roster. High Court's jurisdiction to decide the list may not be questioned. However, exercise of jurisdiction in an individual case outside determination can be questioned in the event such bench assumes jurisdiction beyond the allocation of business by the Honorable Chief Justice. It is really echoing what is for the Supreme Court judgment. Similar to sum up, my lord, A, this was not a hearing matter. B, my lord, the original side rules does not provide for any, my lord, warning list for execution matters. C, Rule 42 of the original side rules, Chapter 17, execution, directs execution application can be dismissed in a particular manner. That has not been followed at all. And D, my lord, this now what we find that after being released, my lord, this was not assigned. So otherwise, my lord, this order is a nullity. So my lord, if 105 does not apply, 106 also does not apply.
Yes. Mr. Mitra.
The learned friends have argued some other petition, maybe he is briefed to argue before some other court. By mistake argued. Can you see the petition, Miller? What the ground taken and what is argued? Petition is down, right? It's maybe by mistake, Miller. But I think, of course, they're getting ready for the other matter, I think, by this process. The petition. My lord, see the petition. Order passed by Justice Kapoor. We let us say a matter will recall. See the ground taken. Ground. Please may not come to paragraph 4 of the affidavit in support of the summons. The matter was listed on 11 July 2023 when, in the absence of petitioners and the learned advocate, the execution petition came to a dismiss. No whisper, the matter was listed wrongly or invalid listing or void listing. No ground is taken.
Yes.
And what has been argued now before lordship? Now see the next paragraph. It is stated that on the said date, matter was called on for hearing. For hearing, can you mark the word? Called on for hearing.
Yes.
But unfortunately, neither the petitioner nor his learned advocate on record could remain present when the matter was taken up. Consequently, unfortunately, that is the slabs. Consequently, said case was dismissed for default by the order dated of Honorable Justice Kapoor, Miller, copy of the annex. They are accepting the validity and correctness of order of dismissal or default. No ground taken, is wrongly passed. Then Miller, kindly see. Then paragraph 12, on 20th January, they came to know that the matter has been see now most important paragraph 14. That the last date for filing of this restoration application was 10th August 2023. That is a delay of 907 days. I pray delay be condoned. In the petition, it is admitted that last date was 10th of July, on 10th of August, and order of dismissal was passed on 11th of July. So they are counting 30 days and accepting that 30 days is the time limit for applying for restoration. Order 1, Rule 106. So petition was The order was, Kapoor's order was a valid order. But it was their unfortunate happening that their advocate did not appear or they did not appear. Matter should be restored. And therefore, condonation of delay. They are admitting that time limit for making the application was 30 days. That is applicability of Rule 105 and Order Rule 106. Petition on that basis. And then ask for condonation of delay of 9 and 7 days. And nothing has been argued on the delay point. Civil Procedure Code, my lord. Kindly see Rule 100, Order 21, Rule 105. The court ruled Order 21, Rule 95, 105, if I may humbly place for your lordship.
Yes.
May I place Rule 105, my lord?
Yes. Hearing of application.
The court before which an application under any of the foregoing rules of this court is pending may fix a date for hearing of the application, where on the day fixed or any other day to which hearing may be adjourned, the applicant does not appear before the case is called, when the case is called, called on for hearing. Then in the petition they admit matter was called on for hearing. Paragraph 5. 4 also. And applicant does not appear, matter court may make an order that application be dismissed. Make an order. Now here the Milord now see, and if the application is dismissed, then sign is here 106(3). Sub-rule 3. An application under sub-rule 1, that is application for setting aside, etc. I mean, I should read sub-rule 1 also, Miller. 106, sub-rule 1. Applicant against whom an order is made under sub-rule 2 of Rule 105, or the opposite party against whom an order is passed, ex party, under Rule 3, or that rule or under sub-rule 23, may apply to the court to set aside the order, and if it satisfies the court that there was sufficient cause for his non-appearance when the application was called on for hearing, the court shall not set aside the order, shall set aside the order on such terms as to cause or otherwise as it thinks fit, and shall appoint a day for further hearing of the application. So the court which has passed that order, he will set aside and fix a date for further hearing. Order was passed by Justice Kapoor. Then 3. An application under sub-rule 1 shall be made within 30 days from the date of the order of dismissal. So they have agreeing, they have limitation period expired on 30 days. That is 3rd July. They admit in the petition, that this matter was called on for hearing, paragraph 5. They also admit that the matter was listed on 11 July. They do not say wrongly listed. They do not say should not have been listed. For whatever reasons. They do not say that there is no notice of hearing was given. Do not say anywhere. Now, what is the argument? First argument, no notice of hearing was given. Why is that case made out? On the other hand, Miller, they accept the validity and correctness of the order of Justice Kapoor and say, we kindly condone the delay and we apply for restoration. Set aside of course restoration. Not, that is why this matter, this application is appearing before your lordship list.
Yes.
Because this application doesn't call or contain any grounds for holding that order of Justice Kapoor was wrong, as they have now argued. That he passed that order without fixed for hearing, matter being fixed for hearing. And he passed that order without fixed for hearing, passed the order. And that is why matter application general list, because of lordship has got the determination for regular bench. They have not preferably appealed from the order of Justice Kapoor. That you heard the matter on a date on which matter is not fixed for hearing, therefore order is without jurisdiction. Now they are arguing this of the petition. Well, first of all, I humbly point out, had it been so, the matter would not have been listed before your lordship. Matter would have been heard by Justice Kapoor list. Because one judge cannot or should not do not sit in appeal over the judgment of another coordinate bench. If I say the Justice Kapoor orders were void without jurisdiction, then I have to go before him to say that you kindly have this point has overlooked you, and therefore you recall the order and set aside the order and restore my application. That is just order 100 rule 6 provide that. They are asking your lordship to set aside the order of another judge of coordinate bench. Now, in course of oral application, not written application. You simply kindly say what abuse of process they are indulging in. If the order of Justice Kapoor was wrong on the ground that he had no jurisdiction, then it was their bounden duty to apply before Justice Kapoor and point out you could recall the order, set aside your order because your jurisdiction lack. Now they come before appropriately, before lordship bench is appropriate because there is in the petition not a whisper that order of Justice Kapoor was without jurisdiction or the matter is not fixed for hearing on that date. Now that's why I say what they've argued, that all something completely dehodes the petition. Ignore it. They are not applied for amendment of petition. And not kindly dismiss it on that ground, that no ground is made out. They have not argued at all for condonation of delay. So sufficient ground was made out for condonation of delay. That point has not argued by them at all. And we see the prayer in the judge's summons, prayer is condoned the delay. Because they are admitting that the limitation was 13th of August 2023, paragraph 14. That is their case in the petition. Extraordinary thing has happened. They argued something which is not in the petition and that are contrary to that petition. Contrary to the petition. Now, this is now take the order of Justice Kapoor. Can it is annexed at page 8 of the petition, page 8. Page 8. None appears on behalf of the parties, nor is any accommodation paid for on their behalf, even in the second call. Matter had been appearing in the warning list. Justice Kapoor has noted that. And the parties are deemed to have had notice that the application would be taken up for hearing today. Notice of hearing, that is the basis of the Kapoor judge proceeding. I should mark the word, application would be taken up for hearing today. Parties had notice of that. It is evident the parties are not interested in proceeding with the application. In view of non-application appearance, the application stand dismissed for default. Now, they have not said anything that order is wrong. Has the landed judge wrongly noted that their notice that matter will be taken up for hearing today? Warning list mentioned in order. But they came up with a petition totally suppressing the warning list. Petition is liable dismissed also on the ground of suppression of very material evidence factor in the matter, which judges mentioned in the order, warning list. And why they have suppressed? Can you see the warning list? There are not one warning list. There are four successive warning lists. We have given a copy. And kindly take this four. There are four warning lists which are given to them, and Doctor can see that. But supplement, can you don't look into it? What do you want to do? Totally new ground, nothing, and that is anything. I'm giving it also a copy. Annexure is there. See that annexure? No. Annexure is there. Warning list. Annexures are there. But take one by one. 4th of July. 4th July, the next one.
So next is 5th July.
15th.
5th
Can you
July.
see anyone? See for the first time being.
7th July.
No. I take the one by one.
Sir, 4th again.
4th July. 4th July. And similar to what is printed there. Lordship, kindly see one very important matter. Code number 30, warning list. Code number 38. 3rd floor, Centenary Building. Code number 38 was code number of Justice Kapoor. Honorable Justice Ravi Kapoor. It's a key.
Sir, item number 90.
Key record. One indicator. Yes. Warning list. This is a warning list on for Tuesday, 4th July. Very good. Now, that is the warning for Tuesday, code number 38, that Kapoor just copied bench. Honorable Justice Kapoor name is given. Then next, I can read on. Warning list next to be transferred to the peremptory list on 10th of July 2023 up to item number 1 to 50. And item number 51 to 100 are next to be transferred to the peremptory list on 11th of July. I'm pausing here. 11th of July. Item number 51 to 90. Please see item number 90. Please see item number 90 at page 8 of the list. EC number 29 oblique 2013, Ritu Kashyap and others, Sarita Arora, name of that R.L. Gaga name is also there. So, Millard, on, it is not mere appearing in the oriental list, warning list. Warning list clearly said this matter will appear on 11th July in the list of Justice Kapoor, code number 38. Notice of hearing was given. Peremptory list means for hearing without. Matter again appearing in the warning list. 5th July. Can you take me note? 5th July. That is on next day. Again, court number 38, 34, central building, single bench. Geographical location also mentioned in case they miss it. Next time they may say geographical location is not mentioned, therefore I missed it. On warning list next to be transferred to the peremptory list on 10th July up to 1 to 50, and item 51 to 100 are next to be transferred to a peremptory list on 11 July. And it is also, can you see item number 90? This matter is again mentioned. As at the page 8. Page 8, item number 90 again. Ritu Kashyap, Sarita Arora. Second notice given that this matter will be appearing in the peremptories, and whose peremptory list it will be appearing, and which court number it will be appearing. Court number 38, third floor. Millard, location of the courtroom also given. Otherwise, I think they might have argued, we didn't know, I did not know the location. They cannot even argue that, at least. At the length where they have gone, they can say so. Then, this is second warning, second notice. Can you hear third notice? Third notice, 7 July 2023. What I am emphasizing in warning is the date on which matter will transfer to the peremptory list of court number 38. Justice Kapoor's bench is mentioned. Again, Milord, can we come to item number 51 to 100 and include item number 90? 90?
89.
89. Now it has some promotion, 89. That is will be page number 8. 89. Now instead of 90 has become 89. Some matter must have been. Page 8. 89. Second matter on the list. Ritu Kashyap, Sarita Arora. Third notice of hearing given. Third notice of hearing, and my Lord Justice Kapoor records hearing notice has been received. Notice of hearing. They deemed to have a notice of hearing. Then fourth notice of hearing. Fourth notice of hearing. That is in 10th July, Monday. The matter will appear next day on the list. Similar now, warning list. Next we transfer to the peremptory list on 11 July up to 1 to 50. Item now out time number 1 to 50 will transfer. And this time 11 July, 39. Item number 39. Please come to page 4. Page 4. Page 4. Item number 39. The fourth one from the bottom. 39. Ritu Kashyap, Sarita Arora. So may I not find. Then ultimately in the peremptory list, next day it appears, this is the peremptory list. This is called daily list now. Item number, look it up. 108 number. At the page number 58, no, page number 58 of 128. There is this. Item number 108. Right. Now we will see the order once more, page 8 of this Lordship Justice Kapoor. No, 3 minutes on page 8. Lordship mark at the bottom, at the top, left-hand side, OD 108. Original side, daily list 108. And the order is far. And Lordship notes, matter has been appearing in the warning list mentioned, and the parties are deemed to have had noticed that this application will be taken up for hearing today, 11 July. So that's the notice of hearing.
Completely suppressed from the.
So, Miller, all these arguments of contrary to the petition, contrary to records. The elaborate judgments and all these things cited for 2 days, if I may say, Miller, wasted your time. Notice of hearing not given. Right? Notice of hearing has been given by the court by issuing a warning list. They do not say that warning list they have not seen. No, not that. They did not come up to court and tell Justice Kapoor that matter happening warning is all that warning list is totally void. You ignored the warning list. Ignored warning list. In the petition, they do not say the warning list was mere something void documents, cannot be looked into. Do not say. Why? Then why this argument? No notice of hearing? 4 several notices of hearing given on 4 different dates. And the court records the notice of hearing. They had noticed the matter fixed for hearing today in my court. In the petition, he was setting aside this order of Justice Kapoor. No ground is taken. That is, order is liable to be set aside on merit. That order is to be set aside because it lacks jurisdiction. No ground is taken that order wrongly records that notice of hearing was given. But it had notice of hearing. Yeah, unfair to the judge. No ground is taken that the order of Mr. Kapoor has wrongly recorded the parties had notice of hearing. And he has wrongly recorded matter appear in the warning list. And or that is no petition, no ground, that his lordship would have ignored the warning list. Warnings were void. Each of the grounds which are orally argued before lordship is totally divorce the petition. Totally divorce the petition. No argument has been made for condonation of delay. Because they know, I not tell you why, because no ground is made out for condonation of delay. No ground at all. Now, my lord, even if order is all right, you make everything, have they told your lordship, main criteria is
No, but Mr. Mitra, you
was
are
a sufficient cause for non-appearing on 11th of July when the order was passed.
I have a question.
My lord.
Are you saying that it is only 105? It's barred by that, where order of dismissal has been passed? Or you are saying that the order which has been passed by Justice Kapoor, it should be decided on merit, in the sense that, you see, it's a dismissal default. So there's no merit which the court has gone into. They have only dismissed it.
Yes.
So the ground which you were initially arguing was only confined to 105. That is barred under 106. But beyond that, you are taking a different plea altogether now.
Yes.
Is it on the merit?
No. Today they are arguing on merits.
So they are not arguing on merit.
On merit of the order. Order of the judge to be set aside. They are now saying the order should be set aside on merit because they had no jurisdiction. Because there's false record in the order, there's no notice of hearing. Yes. Now, my lord, I am firstly saying before confirmation delay, they have not argued confirmation delay, rightly not argued because no ground is met out. I can show to you also no ground is met out. Now, another point they have not argued, that they have sufficient cause for non-appearing on the day matter was called on for hearing. That is a vital thing. Similar to what is the ground taken for non-appearing? On the date. That is the main thing. On the date fixed for hearing, whatever the reason, why they did not appear for hearing on that day. Yes. Please, my lord, see what is the ground taken. Please see. Matter was paragraph 4. Matter was listed on 11 July when, in the absence of petitioners and the learned advocate on record, execution petition came dismissed default. Why? Then paragraph 5. It is stated that on the said date, matter was called on for hearing, but unfortunately, neither the petitioner nor his learned advocate on record could remain present when the matter was taken up. Why they could not remain present? Is it the ground that because they didn't present because they had no notice of hearing? Okay, right? Consequently, case was dismissed. Rightly dismissed. Consequently, they're not blaming the judge. By the order of Honorable Court has been said. Copy of the order annexed. Now let us see the next paragraph. Paragraph 6. The absence of the petitioner and or his advocate on the said date was neither deliberate nor intentional, but due to bona fide and unavoidable reasons beyond their control. What is the reason? So, my lord, it is not that they did not say that the absence was on the ground because they had no notice, matter was not fixed for hearing on that date. Absence was not on the ground, the matter had been assigned, matter was appearing before a wrong court. So, may I ask myself, it is not proper to ask a question to the judge, kindly consider whether anything has been submitted to your lordship, why they did not appear on 11th of July when matter was called on for hearing. What the cause they may have. For whatever reason the matter appeared. If matter appearing by mistake, they should tell the court to the appearing by mistake. They admit. But unfortunately, beyond their control, not because of court's fault. See paragraph 6 once more. Or deliberate, neither deliberate nor intentional, but due to bona fide and unreasonable reasons beyond their control, not because of court's fault. And what is the reason beyond the control? Similar. Similar next ground, paragraph 8, read it. It is stated that during the relevant period, my aged mother was seriously unwell and required constant care. Unfortunately, my mother passed away on September 23, when the order was dismissed, when the 30 days expired. What was 11 July 2023? The date, relevant date here is 11 July 23. Mother died in September 23. My condolence, my sympathy. But does it say that on 11 July, I couldn't appear because the mother's dead? They don't say that. That's why, there being no ground for delay, they are not argued. Why should they answer? I said, take the matter petition on merit. See the grounds made out in the petition.
Yes.
Nothing said against the learned judge's order being wrong. And they're asking another learned judge of coordinate bench to set aside the order of another judge set aside the order. Because this application could be heard by lordship as the petition as it is, only because they are accepting the validity of the order of the learned Judge Kapoor. And they are saying, unfortunately, we could not appear for reasons beyond my control.
So if I accept your argument, then you're saying that this court doesn't have the application is not maintainable. It's an order passed by a coordinate bench, so I can't entertain the petition.
Yes, take it.
And that's exactly what the argument is. If it's an order which has been passed on merit, then obviously I can't hear it.
Yes. That's my lord, may I follow? I said, remote. The petition as it is within my lord's jurisdiction. What my lord is asked by the petition to determine not whether judgment order of Justice Kapoor is right or wrong. It's accepting to be right. They accept order right. And they say order can be condoned or delay. They're saying it was for reasons beyond our control. We could not appear. Therefore, these are the sufficient cause or whatever may be. We are 903 days late. So condone the delay and apply. The question of condonation of delay will arise only if the order is accepted to be valid. If order is void, no question of condonation of delay. Similar to prayer. Prayer now is not that order be adjust void. Similar that judge's summons, a master summons. Master summons. Set aside the order of 11th July, whereby above named matter dismissed. Restore the matter. Then see, delay of 907 days in filing the restoration application be condoned. There is no, and no argument has been made on restoration of delay because no ground has been made out. Petition has been rightly filed before the regular bench, who is taking execution matters. But what they are arguing, this argument not permissible in this bench, before this bench. For two things. Because it is not the case made out in the petition, number one. And what they are arguing is contrary to the petition. Contrary to the petition. Petition accepting the order to be valid. But it is their fault because for reasons beyond their control, they could not appear. Contrary. And thirdly, they are arguing before another bench, another learned judge of coordinate bench, that you set as the order of another learned judge coordinate bench. On the ground, not on the ground order was valid and accepted. On the ground order was bad. Order invalid without jurisdiction. Now, if they made the application on that ground, the application naturally goes for that. Because, I mean, just like I say, not ignore the grounds they made out orally. Each and every ground taken orally, that's why I repeat my submission. They've argued some other petition, not this petition. Petition remains totally no amendment, nothing. So, Lordship is deciding this petition. Now, may I give you Lordship a list of dates? Similar?
Yeah.
List of dates? You just do help with the total. This executive application is not appearing for the first time in the list. First date is 8th September 2023. Then application was filed by 4 petitioners jointly. See another thing. 4 petitioners jointly filed the petition. 24/1/2023. Except move ex parte, identity order injunction obtained. returnable on the 29th February 2023. Then without direction filing affidavit opposition is given. We file affidavit opposition. Another ground, learned judge said, it appears the petition not ready, not interested in the matter. Another important fact, my lord. Direction affidavit was given on 24th January 2023. We filed the affidavit opposition in time. That time for reply expired. When expired? Up till now, they have not filed affidavit reply. This is point to be taken note of in my humble submission. They have not made the application ready for hearing. Up till now, to 2026, after 13 years are expired, they have not made the affidavit, filed an affidavit reply. So that's clear. So learned judges now see that is Kapoor's observation, that it appears that they are not interested in the petition is corroborated. Is corroborated. That can you did a list of dates we have mentioned below. List of dates. Next page, D was going to be and to file affidavit in opposition. Please turn the page, my lord. Reply you extended till 1st October 2013 and matter directed to appear list on 3rd October. So reply time expired on 1st October 2013 and today matter is 28 July. 29 July. 28 July 2026. More than 12 years has expired. Up till now, they have not. Matter was released by Honorable Justice Harish Tandon and be placed before the Honorable Chief Justice for assignment. Order shows that none of the parties appeared. On the Miller, we also did not appear, they did not appear. On the date also, when that fact is important, none of the parties appeared on that date before Justice Tandon. So what is that? That is just as observed, Justice Kapoor observed, appears the party is not interested. What's wrong? Apparently not wrong. Then exam application appear in one like this, appear in daily list. Then last last 10th of August, last day of filing application restoration expired. This is their case in the petition. Now, how can they change it now? Orally change it. Whether notice of hearing was given or not is a question of fact. It's a factual matter. It is not a question of law. Suppose that I gave them a notice, that matter will be hard, your matter will be hard on that. The court has fixed the date for the hearing. Enough. Then 12 years later, to avoid the expired also, long then last date, 6 January 2025, long after expired period of filing restoration application as admitted petition, wife of petitioner allegedly diagnosed with cancer and operated upon. Paragraph 9 of petition. I'm giving the date. Long after 13 years or something, 12 years, I think. Then application for restoration made on 2nd February 2026 by petition number 3 alone, but not filed. Then 20th April 26, restoration application made by petition number 3 was filed after a delay of 9 and 7 days according to the petitioner. But it should be 9 and 7 plus 18 days, where they did not keep the petition in the drawers. 9 and 25 days delay. So, my lord, as my lord observed, wanted to know, I am saying, humbly submitting that the petition discloses no ground for setting aside order of Justice Kapoor and for restoration. Number 1. no argument has been, no petition has, no ground has been out in the petition. There is not a case in the petition at all. That order of Justice Kapoor is wrong. Number three, my lord, in the petition, they have admitted that for reasons beyond their control, they could not appear on the date fixed for hearing, 11th of July. Not because the order was wrong, not because they did not receive notice of hearing. Then, fourth, what is the sufficient cause for non-appearing for 11th July has not been argued, even if everything goes wrong. Then delay of 923 days, we ask for condonation. Unless delay is condoned, the order a petition cannot be hard on merits. No argument has been made for condonation delay because there no ground has been made out. Therefore, Miller, on the merits of the petition, I humbly submit that this petition is bound to be dismissed with cause. I am saying with cause because of the time they have taken, 2 or 2.5 days hearing. They have argued not their petition, but some other points or grounds which are not in the petition and not are really contrary to the petition. Now, Milord, see the judgment they have cited. See the judgment they have cited. Have got any relevancy? নোটটা কোথায় গেল? নোটের পাতাটা আমার নোটটা না 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 এটা ছাপান না হাতে লেখা এর আগে ছিল এখানে এখানে এটা না এটা না গেল কোথায় লিস্ট অফ ডেটস দাও আমার লিস্ট অফ ডেটস দাও লিস্ট অফ ডেটস and notes লেখা এখানে আছে আমার লিস্ট can you see the judgment they have cited one by one আমার লিস্ট অফ ডেটস দাও my lord কোথায় গেল এটা ছাপা লিস্ট অফ ডেটস কোথায় রাখুন they kindly give me a minute looking for my notes kindly there are 4 judgments they have cited in all those cases, all the judgments, the matter which was dismissed for default was not on the list at all for hearing. All the 4 judgments, similar the one by one. Similar, anyone, see the Delhi High Court judgment, 2010 SCC online, Delhi 4,220. Please will not come to that paragraph 1. There are two matters involved. One was the execution application and the application for substitution in the execution application. Confusion and complexities have been particularly confounded in the circumstances of this case. As a concrete account thereof will disclose this execution proceedings have been initiated by Deutsche Ranko GmbH against respondent, Sri Mohan Murthy, who appears before the court in person. On hearing held in EA number, that is the Miller execution application. See petition free. EA number, the execution application. In execution number, that is EA miscellaneous petition, Miller. That was filed in execution number 58 by 1994. That was the execution application. And in that, an interlocutory application made for substitution. It has been minuted that counsel for the decree notice holder submits that he has instruction to withdraw from the case. He submits that he would be moving an application for seeking discharge. At his request, adjourned to 7/8/7. On the next day after hearing, EA number was once again listed for appropriate consideration of the court. The court passed an order reading that. On the last date, 23rd March, counsel for the decree holder had informed the court that he had instruction to withdraw from the case from which he wanted to file the application seeking discharge. No such application has been filed. Neither the counsel nor the decree holder is present. Hence, the execution is dismissed. Matter appearing execution EA number something, that was the application for making substitution in the execution case. So substitution application was fixed for hearing on that date. And that is made very clear later on, out of clear. You know, more clear below. This is 4, placed on a predicament like order application made under Order 9 Rule 4 of the course of procedure for restoration of the execution petition.
Yes.
On 25/1/20, learned single judge was pleased to recall the order dated 7/8/2007, taking support from H.K. Goods judgment, as well as Babulal versus 1950 Allahabad. This special order was recalled without issuing notice to a respondent, judgment debtor, and was thereupon ordered to be issued. And notice, sorry, debtor. Notice number EA, notice of EA, that is the execution administrative application, EA number, was thereupon ordered to be issued. Judgmental respondent thereupon filed the application seeking a review of the order dated 25 January 28, by which dismissal has been recalled. Review has been allowed by the order, and it is those the order which have been assailed before us. That is assailed, and that was set aside. Millard, kindly come to paragraph 7. We have already noted that the learned single judge had proceeded under Order 9 Rule 4 of CPC on being convinced that notice of that application was not required to first issue to the non-applicant. And secondly, on his being satisfied, there was sufficient cause for recalling the dismissal order. Sufficient cause dismissal order is necessary, any event. And thereby restoring execution case. Learned single, etc. We are unable to affirm this analysis. Why? Of the learned single judge, to the effect that Rule 105 and 106 of Order 21 CPC had come into play at this stage. When on 7/8/2007, execution proceedings had been dismissed in default as well as for non-prosecution. Our attention has been drawn to the decision of the learned single judge. Case number is given, Rajasthan High Court judgment, etc. Odisha High Court judgment. Respondent never relied on Supreme Court case also. And we say for the reason that their lordship had proceeded on the assumption that Rule 106 and 21 was incontrovertibly attracted to the situation which had arisen there. His lordship is clear, then below. When decide which has arisen, their lordship was called upon to decide the proper manner in which the period of limitation was to be calculated. What is extremely pithy, so far as the factual matrix before us is concerned, is a specific recording that execution petition had been set down for hearing. on the date on which it came to be dismissed. In this conspectus, we are of the view a single bench referred to above have correctly analyzed the law on the subject. Accordingly, since the execution petition had not been set down for hearing, on 7th of July, it should not have dismissed it. Yes, matter ends there. And the judgment relies upon. Matter was not set down for hearing on that date. What the execution EA number was, that was for substitution of the execution case. So this is judgment strong, and this was followed in the later judgment. Similar case which is not set down for hearing. Take the other judgment now. Come on, take it up. Take out. The 2014 Delhi Milot is same. 2013 SCC online, Delhi 3837. That is the IR 2014 NOC. That was, and my lordship has cited without pointing out to your lordship that suit was dismissed, execution case was dismissed when it was not set down for hearing. This is point or the other point decided. It is a continuation of that 2010 judgment. So I should not bother your lordship too much with that. So, please see. Matter went back remand and then it was argued inherent jurisdiction, sufficient cause or not. Inherent or whatever reason is for setting aside, there must be sufficient reason for non-appearance on the date fixed for hearing. Now, this judgment, can you see the order portion first? What was the order? Similar, and then was argument. Please may not come to paragraph 16 of the judgment. Adverting to the contention of the applicant that the provisions of section 151 CPC cannot apply. That judgment cannot apply for restoring an application which has been dismissed in terms of Order 21 Rule 100, paragraph 16. Reliance is placed upon a case of such and such, and the appellant is no longer at liberty to make that apostate contention. Why? With earlier division bench 2010 had categorically stated that the land single judge had erroneously proceeded under the rule order rule 4, and therefore under the order rule 106 of CPC, and directed that I am show you also the reason why they have. Isn't it matter not set down for hearing on that date? A substitution has been set down for hearing, and that has been said. Therefore, you cannot argue anything. Res judicata. This is a sequence. This matter remanded in 2010. Now final order is coming up. This is not covered. Now see the judgment of other high courts. They have cited. 1986 MP, page 66. देखो ये चौड़ा तो it was Millard. In this case, what was matter that date was fixed for considering the report on warrant of arrest and not for hearing of the execution application. This case. But could not be executed. আমার কাছে নেই আমার বইটা এসেছে দেখো তো it is এমপি আমার বই কি আছে দাও দেখো না দাও দাও আমার লেখা আছে এটা তো whatever বলে দাও এই Any kind of paragraph 18 of the judgment to cut the matter short. Paragraph 18 of the
Yes,
judgment.
yes. In my opinion,
In
the
my
date on which
opinion,
the word hearing is important.
hello?
They are saying that in terms of section 105,
Yes.
the word hearing is relevant.
Oh, I
So
see.
only if the matter is listed for hearing, then 105 comes into play.
Yes, hearing, that's right. But I bow down to my other observation. When there's a matter fixed for hearing, then. And our Justice Kapoor rightly or wrongly held the matter is fixed for hearing on that date. Because they relied on the warning list and said so. If a judgment is wrong, appeal.
So, to my understanding, Mr. Mitra, warning list is not really necessarily a hearing date, right?
Not necessary. It is absolutely
necessary.
relevant in this case.
They are saying what the supplementary affidavit which they have filed, they have also annexed the list, right? The same list which you are relying upon.
They have only annexed the 11th July list. They have not annexed the previous list, which says that it will come up on this date for hearing.
So they have only said, as far as the 10th July list is concerned, they are saying that item number 1 to 50 would be preemptory. Then the second one will be on the 11th, item number 51 to something, 200, and then the next would be on the date 12. So they are saying on the date 11, because since the matter was listed at serial number 90, it was not something which should have come on the 10th, it came on the 11th.
No,
and
no,
that
it's correct. That's the opposite. Kindly have a look at that list one.
Warning list, though.
10th, list of the 10th. That is not their case. That it was wrongly appearing on 11th instead of 10th.
So the 10th July list is here.
Warning list, item number 39. Similar, this is mentioned, it will appearing on the 11th July, 10th July warning list. See the top. 10 July top. 8 top.
Yene.
10 July top.
It's 10 July. If the Lordship has 10 July, 10 July it was said, kindly reads the warning list on the top.
In bold letters, in very bold letters.
This is, you have handed over
Yes. We've given 10th also.
10th.
The list of 10th of July.
Yes.
So if your Lordship sees on the top, warning list next to be transferred to peremptory list on 11 July up to item numbers 1 to 50. So 1 to 50, here it was item number 39 on that day. Have your Lordship got it?
Yes.
Item 39.
At page?
Internal page 4.
Yes.
So, my lords, it was categorically stated on 10 July that it will appear on the 11th July. And it did appear on 11 July as item 108.
Hearing list. No, happy to put the 90. And on 11 July, it was on the hearing list. In the list of it, that's why I mentioned, Milord, that warning list said this matter appeared on 11 July.
If you see the list is just a confusion, nothing else. If you see the list, on 11th, it is item 90, right?
11th, on the date of dismissal, 108.
108. And if you see the new chamber
That's the
application starts from 23. Is coming under the category of new chamber application.
Heading,
That's how
heading,
it comes. That is the practice of the court.
heading.
More importantly, 10th July, if your lordship takes the 10th July list, there it was categorically mentioned that 1 to 50 will appear on 11 July.
It's a photo.
Kindly see, warning list next to be transferred to peremptory list on 11 July.
In bold capital
Up
list.
to item numbers 1 to 50. And when it's in paragraph 5 also.
Yes.
Heading. Heading of all the matters, heading.
All these matters have been dismissed in default.
All.
And it was the same on the similar heading.
Instances also, earlier instances of our High Court where similar things have been done.
I show you orders. Where the court relying on the wording this petition. I've got orders. Can you remember 19 Madhya Pradesh High Court, they have cited, can you see paragraph 18? Yeah. Again, same thing. The matter was not fixed for hearing on the date at all, which was dismissed for default. Execution case not disposed of. It is they have cited SCC online. SCC online দিয়েছো তো নাকি? No, 86 MP Law Journal.
On the High Court website, it says purpose of hearing. And 11.
Well, can we come to paragraph 18? In my opinion, the date on which paragraph 18 minutes.
Yes.
In my opinion, the date on which the execution application was dismissed for default of appearance of the decree holder, namely 25 August 1979, was not a date fixed for hearing with the meaning of Rule 105. It was a date awaiting report as to execution of warrant, which was supposed to be issued on submission, etc. The date for warrant. All these cases have arbitrary judgment দিয়েছে তো বলো শেষ করে তারপর যাচ্ছি আবার আর কি জাজমেন্ট দিয়েছে না জাজমেন্ট কি তারপর তাকে হ্যাঁ আরেকটু জাজমেন্ট আছে আরেকটু জাজমেন্ট আছে এই এমপি have dealt with any other judgment they have cited দেখেছেন all the judgments none of them has application because they're Kerala, দাও Kerala একই জিনিস Kerala একই জিনিস look it's not on a day fixed দেখো Kerala দাও এবার Kerala reference কত এই যে 2005 SCC online Kerala 589 yes. Paragraph 5 and 6 can you see paragraph 5 and 6 of the judgment Kerala paragraph 5 5. I am afraid I cannot agree with the above submission. EP 6598 was filed on 9th March 1998. On 23rd March 1998, executing subcourt posted the EP number EP to 3 to 4 1990 with the following endorsement. Put up with back records. On 3rd April 1998 also, EP was directed to put up with records and posted to 20th May 1998. It was on 20th May 1998 that EP was dismissed for default, since there is no representation on behalf of decree holder. an application on Order 21 Rule 106 CPC postulates that the passing of an order on Sub-Rule 2, Rule 105 of the Order 21, dismissal of an application under Sub-Rule 2 of or 21 presupposes a posting of the case for hearing and failure on the part of the applicant to appear on that date. As noted in earlier EP number, etc., the EP number 6598 was posted on 25/1998, not for hearing, but for being put up with the back records. Not put up for this, not it was not posted, not for hearing. It was really a direction to the bench section to put up the execution petition together with back records. The question of posting EP for hearing the same arises only after it is put up with the back records. Hence, 25th order was not a date fixed for hearing of the execution. All the judgments they have cited,
Similar orders.
Now, astounding argument, warning list in the High Court, etc. Warning list of not only suit, but also of all applications are published in our High Court as per practice from time immemorial. Now, see, I'll show you also other orders.
Chapter different matter action.
There are 4 orders learned juniors have found right of Ravi Kapoor. Turkey.
All execution matters.
Yeah.
All dismissed for default after appearing in the order.
Yes.
Same.
See the Miller? Warning this, all the matter appear in commission judgment. What is the? Can you see the order? Matter had been, that's the Kapoor, 30th of August, another date. Matter, 4 orders, all EC number, etc. All EC number. Matter had been appearing in warning list, and the award holder is deemed to have noticed that his application will be taken up for hearing. EC number 340. None appears on behalf of parties. So, military standard practice to make the EC exo application to appear in the list with warning list. Similar 30th August, another order has been passed, same recording. It matter appeared in the warning list and deemed to have notice. No. Suit, no, আমার কপিটা তো ওটাকে পিটিশন একটা আছে পিটিশন একটা আছে সবমিশনে পিটিশন না আচ্ছা সবমিশনে বাঞ্চ অর্ডার দিয়েছিলে না আছে একটা অর্ডার not only Kapoor Milot, it has been the practice of our court for a long time to issue warning list of suits and also of applications. I've seen the other decision the first time warning list. This is the order of the Somen Sen, which refers to warning list of petition also. But kindly পিটিশন একটা ছিল গেল তো অর্ডারটা দেখিয়েছিল and similar this is what I'm giving to you and GA an application similar GA number 2835. That is GA number 2835. That is application in the made in CS number 318. The matter had appeared in the warning list before being transferred to this bench. Parties have adequate notice and are deemed to have sufficient notice. The matter would appear today before this court. However, none of the parties are represented. It appears parties did not interested to proceed with the matter. Accordingly, GA number 2083, not the suit. Interim order is vacated. So, it is order letter 2018. But it is rather unfortunate, most unfortunate. They said a warning list of petition cannot. Is any bar? Has in provision of rule has been shown that there will be no warning list of petition. There will be warning list of suits mentioned. If we apply section 141 of CPC, it applies to petition also. Petition, suit and petition same. Now, most question is there any bar under our civil procedure, under our rules, that warning list should not be printed or listed of the petition pending? Then practice will prevail. See the High Court rules. See the High Court rules, below. Why do they argue? They argue, they say, yes, I've seen that. Can you see the rule they have referred to? They say there will be warning list of suits. Very good. You see that what they relied upon. They relied on chapter 10, rule 19. All the point is not taken. Nowhere point is taken. In the petition, nowhere point is taken. Then even then, similar to rule 19, order 10, chapter 10, rule 19. A warning list of suits about to be transferred from the prospective list to the peremptory list of defended suits shall be prepared for each court for every day. A warning list of suits about to be transferred to the peremptory list is in bar, and is adding the word, and no other warning list can be published. They are adding the words, and no other warning list can be published. And does the rule say so?
Yes.
It's rule 24 देखिए छोड़ा. Now, seen that, but please, Willard, before we close down, kindly come to the rule 2. Kindly come to chapter, last chapter of the High Court rules. General chapter 40. Right. Chapter 40 milo, general rules. Chapter 40 কি বলবো
practice of
কাজ করলে জানতে
practice has wait,
got it? আমাকে দিন বার করে দিন একদম শেষের দিকে এটা কার বই এটা কার বই পাতা পর উপরটা উল্টে যাও হ্যাঁ এই general rules. Similar rule 2, section 2, rule 3. That's of rule 3. When no other provision is made by the court or by these rules, present procedure and practice shall remain in force. So no rule has been made that no warning list should be published for the petitions. So if that good healthy practice of giving a warning list of petition also, then practice is there and practice continuing. I am here for more than 60 years. I am seeing this warning list of first time I am hearing. There's a warning list of petition. It is administrative and judicial notice is given for this. It's a good practice. A practice has been followed. And the rules will not. The registrar also has given a report. Registrar asked him if he knows better than me, tell him the truth. Warning list, I have given a warning list reference of the Justice Showmanship. But date got over. 2018. Order of Showmanship. He is referring to warning list of GA, general application. It's a practice we have seen. And I'm sure learned friends have been brought up with this practice. Now, how could that happen? No. Milord, may I, with my lord, kind leave, my lord, submitted the report of the registrar, giving copy to them. Yes. We, by a letter, ask him to speak out. As directed, I am to inform you that this is the prevailing practice and procedure that the caption matter appear in the warning list under heading New Chamber Application and transfer to the peremptory list, daily bracket, daily cost list, on the same heading on their respective dates as indicated in a list dated 4th July, as per the direction of this Honorable Court. Practice, 100 years practice there. What they're saying unnecessarily. I could understand the rule, there's a prohibition that warning list of only suits will apply and no other warnings. I could have understood that. Then I argued rule is contrary to practice. What is this argument? Now see the next, I am dealing with the argument without prejudice. That this argument should not be taken note of by your lordship, because not in the case in the petition. Lord, practice everything we have said, warning list is bad. They never said now, I have not said so. Then see what other thing they have argued, no notice of hearing. Then it does record, warning list gives a notice, 4 notices were given. 4 notices were given, the matter will be transferred to parent police. For chatting, matter being transferred to daily cost list is for chatting or gossiping. All the matters are listed for hearing. All the matters. Heading, you can just register later, can you take note of? Then what are the arguments they have made?
The report which was called for, that report record that they did not take any steps for assignment.
Now, regarding assignment, they make out the assignment. Today, Mr. Gupta argued, no? Assignment. Now, Raisa has given a report to your lordship. I have not seen it. That
you can see it if you want to see it.
Raisa had given a report which was placed before lordship. First when my lord direction gave this a report. কি রিপোর্টে কি লিখেছেন আমি জানি না আমি তো পড়িনি এইটা তো
You can inspect it, you can see it if you want to see it.
Patient. Let us grateful to my lord, I am seeing the report. Lordship order is 14 July. Learned petitioner refutes and submits. Matter was not in fact listed for hearing on that date. It was dismissed for default. In this regard, Mr. Chaudhary, Learned Counsel, has drawn the attention of the court to an order dated 19 March. Justice Harish Tandon recused himself and requested the matter be placed before the Honorable Justice for assignment, Chief Justice assignment. No order assignment passed. Learned Raisa rejected report. Then, after I've seen that, then should I read it?
No need. I've seen it.
No, should read it.
For you said you have not seen it, so I handed it over to you.
Let me read it to myself. I don't have to bother you, Lordship. He is also referring to Milord in paragraph 2, flag D, have been according to the prevailing practice in the year 2016, when the matter was released by a concerned bench.
The lawyer had to write a letter so that they were taken.
Okay. Concerned bench used to communicate order copies of London Registrar, seeking assignment, etc. Also, just making a docket. In the instant case, after going to the department record, it appears that no docket was made for assignment, and hence, and hence it may be assumed the concerned London advocate did not communicate the release order, etc., to the registry for assignment. Because petitioner has got carriage of proceedings. He got the order, saw the order, and he took no step for assignment. That is why we are not interested. Number, what is that order? This is not going deep. Is that a mandatory order? Directing that Justice Tandon could possibly have given a mandatory order. It's a procedural direction, directory order. Nobody has a mandatory order that must be placed before the Chief Justice assignment. And unless assignment is made by Chief Justice, it cannot be placed before any other bench. Is that order meaning? Simply directory order is given. It's procedural direction. And they took no steps to implement that order. And they said no docket was even prepared. Question is, that all the judgments cited, question is on the date. The matter appeared in the list of Justice Kapoor. It has duly appeared before the regular bench. Was taking up execution petitions. It was with warning, with notice, was appearing on the list. A landed judge can release the matter always and say, place it before the release. But if there no step is taken for frequent place, then the matter will infinitely hang in the air. What was passed by Justice Tandon in 2013? 2016. And one it is appearing, published after 9 years in 2026. And for whole week, whole warnings appeared. Then they do not say that warnings is bad. You cannot appear. This matter cannot appear. What is not a petition made in gross abuse of process of court without no grounds, and these grounds are made. Now, only I conclude by submitting the 2005 Supreme Court cases. Page 300. Page 300. No. Page 300. Which they have cited.
Para 19. Para 19.
2005. I'm deliberately not citing any new judgment to prevent them again taking adjournment on. I'm deliberately not writing in new judgment, to prevent them from taking it down and taking adjournment again. This is a small matter. We are incurring cost. That was the case, 2005 Supreme Court cases. And let me not come to the judgment. Okay. When it become this. No. That one I can put out. To the page 300. Here, Supreme Court has said that this 30 days period of limitation, which admitted by them, cannot be extended by the court. Court has no jurisdiction. I'm only pointing out that thing. Similarly, admitting the 30 days period of limitation in the petition. নোটটা কোথায় লিস্ট অফ ডেটটা কোথায় গেল? কোথায় গেল? সরি, কোথায় গেল লিস্ট অফ ডেটটা? Wait. Because supplementary affidavit they had prepared, please don't take them on record.
Why?
Because a leave was given by a lordship to file supplementary affidavit to annex the warning lists which are disclosed by us. Now, in supplementary affidavit, they have made a new case, contrary to the petition.
We have already taken the supplementary up, right? We'll see that. What has to
At
be
this last supplementary affidavit, last two.
Yes.
But that is supplementary lordship can you see. Doesn't remember we disclosed the 4 warning lists, copy given to them, and we submitted to lordship. And lordship tell them file a supplementary affidavit. Ask them enclosing those 4 warning lists. And annexure to the supplementary affidavit, I have no objections. But in the affidavit, supplementary affidavit, they made out a new case that no notice of hearing was given. That case was not made out, that probably was not given. Lordship was not pleased to give any direction upon or leave to them to file any affidavit raising new contention, number 1, and contention contrary to the petition. You may not even think not, the order doesn't say, supplementary affidavit, leave is given, Lordship is saying. For what? For making out the new case. That if that argument is remained out, then I have side judgments. Showing that it is laid down, laid down by our division bench, and even now by Supreme Court and the 3 judge and special bench, that by supplementary affidavit, one cannot alter or amend the petition. The only thing they can have, if they want to alter, they have to apply for amendment. Not the supplementary. There are 3 judgments.
You can show anything, Mr. Mitra, whatever you want to
So,
show. I'm ready
that's
to-
why I'm saying, this point, don't take note of the supplementary affidavit text. Annex is all right. That contrary to what they've said in the petition, new contention cannot be raised by supplementary affidavit.
You can rely on any judgment to show any point. There is no problem.
Yes. So started from a division bench judgment, then Supreme Court judgment, Supreme Court judgment, Justice Dipankar Datta, followed by our 3 judgments, special full bench judgment also. It cannot be done. I can give one judgment. Judgment Supreme Court judgment Dipankar Datta judgment 2005 যেটা ওরা 2005 এই তো আছে যেটা কোন সাইড করেছে না আজকে Dipankar Datta judgmentটা 2005
না
করেনি oh one judgment hand is there giving it lordship this is Jessop's case giving a copy with the copy to one paragraph our division bench judgment paragraph 33, 34. Copy doesn't give us. In this case, my lord, paragraph, just see the preceding paragraph 11, supplement affidavit on behalf of writ petition, affirmation, so many affidavits have been filed. Then 30. All these documents were filed after filing of the writ petition, and on the basis of these subsequent documents and supplementary affidavit, an entirely new case was sought to be built up, which was never put up in the pleadings. We shall deal with this point subsequently. At present, the question is whether this kind of procedure adopted by the writ petitioner before the learned single judge was for developing a new case by filing supplementary affidavit should be accepted or not. We are conscious that in the writ jurisdiction, provisions of the Civil Procedure Code with regard to pleadings are not required to be strictly adhered to. But the basic principle of law of pleading has to be kept in view. A writ petition cannot be dehorsed the minimum pleading. In the present case, we have pointed out above that the entire case put up before the learned single judge was on the question whether JCL, Jessup Company, my lord, comes within the meaning of strategic sector or not. Prayer also made to this effect as they produced, but by way of supplementary affidavit, all these new pleadings were sought to be introduced. This mode cannot be countenanced. If the petitioner wanted to challenge the entire process of the selection of the promoter in this process, then it was binding on the petitioner to amend the petition and incorporate all these grounds. But a peculiar method was adopted by the petitioner to bring out a new case by filing supplementary affidavits and annexing documents from time to time to make it impossible for the court as well as for other parties to meet the case of the petitioner. We cannot approve of this kind of practice, and it has to be disapproved in no uncertain terms. We can appreciate the subsequent events after filing of this petition has taken place, and in the parties, these are not subsequent events, you know. After filing of this petition, this new development, then court in its liberal approach takes into subsequent liberal approach. But these are not subsequent events, what they're giving in the new case. However, therefore, opinion, submission of Mr. Kapoor deserves to be accepted. The new case which has been sought to be developed by the petitioner by inserting various documents through affidavits cannot be countenanced, and we strongly disapprove the approach. You know, this judgment is started of division bench, but I tell you the judgment of Supreme Court. Kindly see paragraph 30, read.
34.
Kindly next paragraph. However, learned single judge has accepted a new case developed by the writ petition on the basis of supplementary affidavits and has struck down the decision process of decision in favor of Rua Cortex, and also held order passed by the BIFR is not legal, and the same has been struck down. We have to consider in detail all these aspects of. We have left the matter as it is, but those findings has given the learned judge single on the question of decision-making process. Now the BIFR has been set aside. We need not examine. We need to examine. Can I put the good? 33 is enough. Paragraph 33 is enough. 33 is enough, enough. কোনটা? এই তো বলছি, followed by High Court, I can judgment of Supreme Court. Same effect, Justice Dupont got to deliver the judgment, and followed by about 3 judgments. I've got the references. We have to give a lot of judgment, and followed by our other single bench also. These judgments follow single bench also. They better. Put the contract, but they better. Learned wants to give a judgment of another single bench on this.
Subsequently followed by our High Court, followed in 2023. We take paragraph 20. Paragraph 15 is where Jessup's was followed. Paragraphs 15, 20, and 25.
Yes.
With another coordinate bench judgment, lot of 2021. But kindly see paragraph 10 of this one. Coordinate bench of our High Court.
Same.
And kindly take this one. This is also one. Here it was diffused also. But this one does not have paragraph numbers. Kindly takes internal page 2 from the last sentence, and if the lordship takes internal page 3. It's a short judgment. It starts from, it is explicit from the arguments made in the affidavit in respect, the petition not challenging the procedure, no ground challenging the applicability of the recruitment via supplementary affidavit. The petitioner has sought to introduce new grounds of challenge. Well settled by way of some new case cannot be made out, fresh grounds cannot, such legal proposition just subsist from it.
Well, that's last minute, 2005. Volume, they have cited that. I deal with the judgment. Volume 5, Volume 7, Supreme Court cases, page 300. Copy to 2005.
But he wants to show your lordship the Damodaran judgment.
You already showed it.
Damodaran Pillai.
Para 18 of that.
Para 18
They had relied on para 18 of Damodaran.
Hearing hearing
Is the same principle which was in the earlier one, where the hearing word is being defined that
hearing word hearing
Hearing. That's here. And the judgment Miller says that it is in this case no dispute. In the petition, there is no dispute that order is filed, order is made by Justice Kapoor on Order 21, Rule 105 and Rule 106. There is no dispute. So a new case will allowed to not made out. And if they allow this ground to be taken behind the back of Justice Kapoor without giving an opportunity to a wrong approach. Because the court has no jurisdiction, and anyway, they have not argued on condonation of delay, so I need not. Those are my humble submission. Sure.
Lordship, kindly take it up tomorrow or any other day, my lord, so that my senior could.
I have not cited these cases.
next Tuesday.
It will take 1 minute. If my lord will be kind enough to take.
What kind of practice is this? What indulgence you want?
My lord, as we have completed our pleadings, we just need a date to advance put our final arguments with the judgments that we need to place.
Next time, whenever the matter.
Shortest possible date by your lordship. Sorry, seeking indulgence, my lord.
Only. You think we are doing
As it
something
is
else?
supposed to take Tuesday only, my lord, that's why I'm saying.